that this session will be recorded to ensure that research and expertise provided by the presenters is shared outside of this workshop. As such, all final recordings will be posted on our YouTube account at the Research Center for Climate Law. Doctoral candidate presentations are based on ongoing research by each of the candidates prior to their final thesis, and so we ask that all attendees and presenters are aware of this when engaging with the content shared. Taking that this workshop will be held fully online, it is not unlikely that speakers or presenters, due to technical and/or other reasons, may find difficulty to join and/or present. We will need to be flexibly responsive to fill such gaps when and if they arise. To go back to today's agenda, the structure of the day is split into a lecture session and doctoral candidate presentations. And for today's workshop, we will also be having a closing session where we will discuss the outcomes of this workshop and last year's workshop, as well as the way forward. During the lecture session, each speaker will have 30 minutes or longer in the case of the panel sessions, which will be utilized at the discretion of the presenter. We will then have a question and answer session and discussion with all the presenters at the end of the lecture session. After our lecture session, we intend on having a brief coffee break where everyone can stretch their legs and grab a cup of coffee. And then we will move on to our doctoral candidate presentations, which will consist of a 10-minute presentation and 10-minute question and answer for each candidate. The Q&A will begin with a question from experts and then move on to the floor for the question session. If your question doesn't get answered at any point during the workshop, please feel free to post it in the chat or to ask again at a later stage. We are more than happy and more than willing to engage with you further. Once again, before I move on to the agenda for today, I would now like to provide an opportunity to just go over yesterday's panel. We had a panel discussion yesterday consisting of sustainable trade. We had three presenters discussing sustainable trade elements. Firstly was Professor Alessandro Monti, who discussed the role of trade and investment law for climate change. He discussed the correlation between BITs and FTAs and their role for in achieving climate commitments. He looked at investment law as a framework for climate action by outlining the promotion of investments, the standards of protection, the expansion of the policy space, and dispute settlement more specifically. He then provided an overview of the expanding policy space for climate goals. He made reference to climate commitments, the duties of investors, the implementation of the Paris Agreement, fair and equitable treatment, and the right to regulate. He also provided an oversight of the need for promoting trade and investment in climate friendly sectors and the facilitation of green investments. In conclusion, he stated three main goals. Firstly, that climate provisions are still largely absent in international investment agreements. Secondly, the new generation of FTAs are more ambitious than BITs regarding climate action. And lastly, strengthening consistency of international investment agreements with climate goals should lead to the achievement of both the Paris Agreement and boost legitimacy of BITs and FTAs respectively. Our second speaker was Professor Matteo Famiglia, who presented on investor-state dispute settlements and domestic climate action. He built on the first presentation, which was on investment law broadly speaking, and spoke more particularly at the collision course, which he defined within investor-state dispute settlement and climate action. He gave us an overview of the current state of affairs and went into a more in-depth analysis on defining climate-related ISDS cases. He looked more predominantly at the Rockhopper versus Italy case and the PV Investors versus Spain case, thus providing a conclusion on the state of ISDS and the need that such cases play a role in the mechanism for anti-regulatory climate change litigation. The last presenter for yesterday's session was Dr. Rita Simon, and she presented on sustainable consumption and greenwashing, reflecting upon new EU legislative drafts, such as directives on empowering consumers for the green transition. In her presentation, she discussed the shift to a green economy and sustainability. She then provided an overview of the market reaction to greenwashing, namely its definition and what she pointed out as the greenwashing sins, so to say, as well as the subtypes of greenwashing that we can expect. She went on further to provide an overview of the disrupting effects of greenwashing and the existing legal framework for greenwashing and determining whether this was in fact sufficient. She highlighted that the existing greenwashing framework at an EU level is both fragmented and a multi-layered legal framework. However, there is hope for this directive and for this framework, as we are expecting amendments of the UCPD directive, which should bring more light onto greenwashing and a better safety net against greenwashing in the future, as it outlines new definitions, new practices, and it brings to light important issues regarding greenwashing, respectively. Now, once again, I would like to move on to today's agenda. So yesterday we built the foundations for sustainable trade, and we ended our session with discussing transitions and just transitions, mainly speaking in the energy sector. And I think that yesterday's topic leads perfectly into today's topic, which is a closer look on climate change and just transition, looking at the premises, the foundations, examples and case studies of various sectors and country perspectives in the goal for carbon neutrality. Today, we have 5 speakers presenting, all presenting on different elements of just transitions or energy law, corporate due diligence, or the move to a carbon neutral society. Our first speaker for today is Professor Raphael J. Heffron. He is a professor at the University of Pau and Adour countries in France and senior counsel at Janson in Belgium. He will be presenting on just transition litigation, a minimum performance standard. Over to you, Professor Heffron.
Thank you. Are you able to hear me?
Yes, we are able to hear you.
Can you see the screen?
Yes, we can.
Okay. Firstly, thank you very much for the invitation to speak today. I'm actually in the midst of another conference in Poland and not too far away, but just for your own interest and for other speakers' interests, it's a conference on exactly the same similar topics of energy justice, the just transition, the energy transition. So demonstrates that it's all very important. So today I'm going to speak about just transition litigation, and just for you to think of a minimum performance that should be standard. So I think I was introduced already, but just to highlight, I currently am a professor in energy justice and the social contract in the University of Pau in the southwest of France. I'm also a EU Commission Jean Monnet professor, and I have experience from different universities around the world as a visiting professor. You can see the list there. And why I say that is today, I also want to give a global perspective, a global view. And in terms of thinking about the just transition, which it seems you've been talking about yesterday, but what I want to say is that when we think of the just transition globally, we think of the rise of justice and why it's become so important, and why then it has resulted in litigation and ended up in our courtrooms across the world. And the key reasons are, when you're thinking of the just transition journey, it really started out after the Paris Agreement in 2015, when 197 countries signed up to this agreement in the space of 3 years. And normally, many of you will know, many international agreements take decades for countries to agree to join. However, within 3 years, 197 joined this one. And associated with that in 2015 was the introduction of the UN Sustainable Development Goals, the 17 Sustainable Development Goals. But many people across the world, they argue about what does the justice mean in the just transition. And I think what we are seeing today is a key determination of what that is. And we're seeing that in the courtrooms today. That has been, let's say, argued in the courtrooms across the world as we speak. But essentially, what we can think of the just transition is three key issues. So if you're talking to anyone, you can say, well, these three key issues have really prompted the rise for justice in our society today. And that's why we have this just transition. So these three issues are the issue of addressing inequality. We all know we live in a world where inequality is on the rise. The rich are getting more rich, and the poor are getting poorer. And that is well documented in economics literature. We also live in a world where we need to move to new clean technology. We have this technology available. The problem is getting it into the market and at a reasonable cost and getting fair prices on energy. And then thirdly, we have the impacts of climate change, which we have been experiencing all around the world. You see nearly every week there's a new country that is experiencing the extreme effect change, exceeding many of the different tipping points. And the tipping point is defined as, you know, when we go beyond something in nature where the change essentially is irreversible. And that's what we're targeting by 2030 and 2050 for the Paris Agreement goals that countries signed up to in 2030 and 2050. So that's the, you know, significance of the Paris Agreement. And this slide here, to me, is a very good slide if you have any remaining climate change denier friends. And we think, you know, what are we working for every year when we have these COP conferences? And we are working towards energy independence, preserving rainforests, sustainability, green jobs, livable cities, renewables, clean water, air, healthy children. And as the person there says, what if it's a big hoax and we create a world, better world for nothing? And that's what we should remember. We are trying to create a better world. And that's the movement. That's what we're doing in the just transition. And that's what you need to remind people. That's what we're working towards. Because currently, with the system in place where we are using old technology, one of the last remaining sectors in society where we actually choose to use old world technology instead of the new best clean technology available. And that's what we need to remember. We're working towards these common goals. And you can see all the 17 goals here, and some of the key ones, obviously number 7, affordable and clean energy. Number 8, decent work and economic growth. 10, reduced inequalities. 13, climate action, as well as all the other ones being vital. But actually, research shows that if you solve number 7, the UN Sustainable Development Goal on energy, you will go a long way to solving all the other 16 Sustainable Development Goals. And what I want to highlight here is that, you know, clearly climate change is happening, and for energy contributes 2/3 of the world's greenhouse gas emissions. So, I mean, for me, energy is the low-hanging fruit. It is the one that we can target more so than when we think about, you know, food or even some people talking about plane travel. Energy is the one that we can target far more easily, since it's responsible for the majority of greenhouse gas emissions and the majority of carbon dioxide emissions. And, you know, the idea here is that energy is based on science, and it works the same way everywhere. We should be able to target it in exactly the same way. It's the same technology. And when we reflect on the legal system, we should be thinking that, unfortunately, today, too many energy lawyers are out of date. And generally too many lawyers are out of date because these changes are happening and we should be responding collectively as a unit or a, let's say, association of lawyers all around the world. The change to date is too slow. If you want to read more, this is in the top energy law journal. You can take that reference and read that article. And it gives different insights to different issues in terms of lawyers being out of date on the climate change issue. And, you know, that's what we want to remember is we need more progress, and we need that progress to happen much faster than it is happening. So when we think of the energy lawyers being out of date, what we need to think about are key issues around energy projects. And this, for me, highlights why lawyers are out of date. When we think about an energy project specifically, we think about planning, construction, operation, and decommissioning. This is the project life cycle. And unfortunately, too often, lawyers were not thinking about decommissioning. So there was no regulation in place for when an energy project finished, what would happen to that energy project, what would happen, essentially all the waste from the operation and decommissioning phases. And that's why we have the problem of carbon dioxide, because we never dealt with it. It's why we have decommissioning problems, cleaning up after energy, because we never put the law in place. And what we need today, and what they are already doing in some countries, is beginning to put law in place that the minute you start out in the planning phase, you have to show how you're going to decommission. And some of you may be aware of different countries, particularly, let's say, here in Europe, using nuclear energy. And if you actually look at the nuclear energy law, you see in nuclear energy law, they actually have regulation in place for decommissioning. And if you build a nuclear power plant, the minute you start using electricity, you pay into a decommissioning fund. However, that is not the same for coal, oil, or gas. And we have to ask the question, if we have the legislation in place for nuclear energy, why don't we have it in place for coal, oil, or gas? And there's a big question mark there. So although I said energy lawyers are out of date, you could argue, are they paid in not had law in place for these other energy sources? And this also reflects on a key question in terms of when I talk about the just transition, and we need to think about the cost. And we need to think here of, if we are not charging for decommissioning costs or waste management, that makes oil, gas, and coal look far cheaper than they are. That makes nuclear energy appear far more expensive, and it makes wind and solar appear far more expensive. So the next time someone says to you, well, we can't afford to have the clean energy, the other energy is cheaper, well, actually, you should ask them for a full cost calculation. And often the cost calculations for oil, gas, and coal include nothing for decommissioning or any sort of waste management. And that's what we need to see today, is full cost evaluation of different energy sources. And again, that is another area where lawyers need to improve in terms of addressing that information. And here are different risks that we look for in the project lifespan. So when we're thinking of these different risks, this is an early indication, let's say, of where a lot of legal disputes are arising, and also where a lot of litigation is beginning to happen on these key issues. You know, countries or companies not playing their role in the 2015 COP21 agreement. We had a couple of cases in the Netherlands over the last few years, one against the government, one against Shell, an energy company. We have many issues. So I know one of the speakers yesterday was maybe talking about arbitration issues in the energy sector. And there you have many issues around disclosure, transparency, a rise in imagery and data. We can think today, if a company misbehaves, images of that misbehavior, of that pollution that the company has done, that can be transmitted around the world. We also have taxation issues, project finance, environmental impact assessments, insurance. Today, it's now very hard to get insurance to build a new coal project. The rules of foreign investment are set up traditionally for energy companies to exploit. So that's another area where significant change is needed. And again, we are seeing more litigation challenging those outdated rules around foreign investment. And if you want to read more, there's a reference there as well. So when we think of these litigation around those 12 key risk areas around energy projects, what we need to see are more independent experts to evaluate those risks. What we don't want to see are people who've worked in the industry for 20, 30 years with the outdated views. We need to see new independent experts who did not work for these companies in the past, and then as they retired, they went off and created their own expert consultancy companies. We want to have more foreseeability around climate and energy issues. Today we have the science, we can use the science to make certain predictions, and that's where the issue of foreseeability should be more prevalent in legal practice today. Sadly, it's not. But what we do see are ethics changing, and one of the big groups I'd encourage you all to maybe sign up to, at least to see what they're doing, are the Law Students for Climate Accountability. They're doing tremendous work in several areas. Another group in the UK, Lawyers Are Responsible. In 2023, they have declared that they will not represent fossil fuel energy companies, I believe. And they have also led some of the new policy document by the Solicitors Association in the UK. You could read that. It was just published this year in 2023. For me, it's surprising it took so long for the solicitors regulatory body to produce something on climate change. Only producing one in 2023 is far too late, but at least it is there now, finally, in print. So there are some initiatives happening to change things. So, going back to theory around justice, around the just transition, or more specifically in energy justice, and I'm not going to explain these in great detail. They're distributive, procedural, restorative, recognition, and cosmopolitan. But what I will say is practice is beginning to change. And in many ways, some of the litigation issues will be expected to rise specifically around justice. And to highlight this, I'm giving an example from a new piece of legislation passed in the US last year, the Bipartisan Infrastructure Law, which creates 62 billion worth of investment in energy. And if you want to access that 62 billion worth of subsidies, you have to show in the project design how your project will incorporate these 4 forms of justice: procedural, distributive, recognition, and restorative. So to me, this is one of the most significant pieces of legislation for climate change essentially since the year 2015. So I would encourage you all to have a look at this piece of legislation if this is your area. And what it requires you is to show how you brought in these types of justice into your project design. And this will have a transformative effect on ensuring that projects in the United States are built with a key justice motivation behind the project. And what's very interesting about the project is, or about the US legislation, is the definitions they took for justice are straight from these 5 academic sources. So actually, there are one from the EPA there in the US, but the other 4 are academic work. So they're actually taking what academics are saying, academic researchers. And number 3 is actually a justice workbook, which is largely based on my own work. And number 5 is another academics and myself work. So they're actually using that work directly to say this is the definition of what this justice is and what we should be trying to achieve. So significant work where academic theory has crossed directly into practice and is changing things. And, you know, if you're not fully convinced that change is in the air, what I would like to show again when we're thinking of litigation, that energy multinationals are being challenged today by the growth really of human rights, the practice of human rights in courtrooms around the world. This is happening in both developed countries and developing world countries. And you can read more about this in Nature Energy, which is one of the top journal for any discipline in terms of energy research in the world. And for me, it's very interesting that they are very interested in legal research today. So this, for me, is very informative. And just as a takeaway message, I think I'm coming up to the 20 minutes to maybe leave time for a bit of Q&A, that I would encourage you also, for those who are interested, if, let's say I had an hour to speak, I would go into more depth, but you can read more in this paper. You can contact me if you want a copy. But for the young and hungry lawyers out there, this paper, again, in one of the top interdisciplinary journals in the world who are publishing more on justice research, this looks at 100 legal cases around the world on justice and human rights. So if you want to find out more, what you will see is that the movement is gathering in terms of the search for a just transition. And this has been focused, let's say, trying to target the energy sector, which, as I said, is responsible for the majority of carbon dioxide and greenhouse gas emissions. And you can see this in the 100 cases around the world. And after looking at this, what we constructed was this energy justice circle, where we think about the energy life cycle from extraction to production, operation and supply, consumption, decommissioning and waste management. But what you see in the center, in the middle of the center in blue, are the rights. These are the rights that we see being protected in all those cases around the world, and those 100 cases around the world, from and we see property, culture, fair trial, security, environment, water, subsistence, life, health, air, dignity. So we see these as being protected in the court documents, in the judgments, in all those cases. And if you want to read more, the article outlines gives the detail on all those 100 cases. So a good source of information for anyone who wants to read or utilize cases in your own research or in your coursework. So, you know, if you want to follow more, you can follow our team. We focus on energy justice and the social contract. We have a growing team. We have 14 researchers to date working on these topics. If you are interested, we will be recruiting very soon for 1 PhD and 3 postdoc positions. So if you want to contribute to changing views in this area, do get in touch. We are holding our own annual conference later in June. Again, I can send more details to those who are interested. And anyone who wants a copy of these books, The Challenge for Energy Justice, Correcting Human Rights Abuses, or Achieving a Just Transition to a Low Carbon Economy, if you want a copy, just send me an email on either of those emails above. So thank you very much for listening today, and I'll be happy to take any questions in this Q&A after my talk. Thank you.
Thank you so much, Professor Heffron, for your contributions and for your takes on just transition litigation and the minimum performance standard. I must say this is particularly of interest to me, as this is an element of my PhD thesis. So I do have a few questions, but I won't monopolize the floor. We have about 5 to 10 minutes before we move on to our next presenter. So if someone else would like to ask any questions or put any comments forward, please feel free to write it in the chat or to raise your hand accordingly, and we can unmute you. So while we wait for that, Professor Heffron, I just have a question for you regarding just transitions, broadly speaking, and the implementation in just transition agreements. We are seeing that, especially between global North countries and global South countries, more specifically after COP26, there was the just transition agreement between some European Union member states and South Africa. We do see those just transition agreements being sort of a bridge between, especially in the global South, between what is known as fossil fuel intensive economy to the carbon neutral economy as a means to achieve that in terms of sharing both funding, skills, and resources. So I wanted to know from you, with the establishment of these agreements, do we see the opportunity to ensure energy justice within these agreements if they do come to pass? I mean, at this stage, they are political declarations, so there is the possibility that these agreements might see the light of day at some point. So in your personal opinion, do we see a greater chance of these agreements holding some sort of weight in terms of promoting energy justice? Or is this something that we need to change more specifically at a national level in energy law?
It's a very good question. What I would say is we need multiple things to happen. So we need energy law to change at a national level as well. But what I would say, these partnerships could be very influential if countries group together. So consider, for example, countries grouping together to buy, solar panels in bulk of China, or buy wind power in bulk of different countries, so that you use it to make things cheaper globally. So rather than, let's say, South Africa trying to negotiate different agreements for technology or expertise, as you said, it's 7-8 countries coming together to say, we all want this over the next 10 years. This is going to be what we need. This is what our markets need now. What can you provide us with? And if you don't provide it, we will go to another supplier. The supply market is becoming much more competitive than it was 5 years ago. And that's, to me, where I see the real value of these just transition partnerships.
Thank you so much for that. I completely agree with you. I'd now like to hand over to Jose. If you could unmute yourself and we can hear your question.
Yeah. Professor Heffron, just one quick question, because I am dealing with the right to energy in my PhD thesis, and I would be interested in your experiences on energy litigation. Have you found any trend on energy litigation regarding human rights? And my main focus on my question is specifically with this specific topic. Have you identified any trend on human rights litigation within energy transition and so on? Thanks.
Yes. So in terms of the trend that we would have identified, that trend would be what's in the middle of that energy justice circle. So to date, I wouldn't say that there is a classic view of, let's say, a right to energy, because we should be thinking there should only be a right to clean energy. And we don't want the fossil fuel community will only be too happy to say that there should be a right to energy, because they will say, well, our energy is cheaper, even though for me, what good is a right to dirty energy in 100 years when the world is no longer exists? So we need to remember it should be a right to clean energy. And I know you have a complex job in your hands in terms of your PhD, but for me, I would be saying it would, rather than a right to energy, it could be, I think strategically, I think it could be easier to focus on the other rights in order to achieve, let's say, a right to clean energy. That if you get all the other rights, you actually, the result would be that you would essentially have a right to clean energy. And I think, just maybe as a final point, when we think of countries in the global south, one of the views I get is, well, we need cheap energy. And we forget that a lot of people live in rural areas, non-urban areas in the global south. And my question would be, how are we going to build gas pipelines out to people living in the countryside? It would be far easier to give them a solar panel or give them a wind turbine, and they can use the energy freely. So I think I think you'll have a very interesting thesis, but I think the rights in the circle we identified, that's the trend in terms of those 100 cases that we took, and most those 100 cases were from 2015. So we took them from the year of the Paris Agreement, so 2015 to 2021, so a 6-year period.
Thank you so much for that question, Jose, and thank you to Professor Heffron for your question, for your response to that question. Carlotta, I'd hand over to you before we move on to our next speaker.
Thank you. Yes, so I found very interesting, Professor Heffron, this energy justice framework and the different dimensions of justice. I was wondering whether there is a way to operationalize these different definitions of justice, now redistributive, restorative, and so on. So because there is a very similar way, a very similar debate in the fair share to climate mitigation debate, no, where different interpretations of justice are put together to calculate how much a specific country has to contribute to the global efforts to mitigate climate change. So my question is, if like you would see a way to indeed then hold accountable a country because it hasn't done its fair share when it comes to energy justice somehow.
Yeah, that's what we would be working for, is to identify those countries that had various injustices. And what you'd be looking then is they need to change the law. And if they don't change the law, they become countries that are higher risk. And by being a country that is higher risk, it'll be more expensive for that country and the industry to borrow money internationally. So that's what we would be working towards, saying is, the higher risk country you are, if you don't correct these injustices, that will result in anything you do being a higher risk. So in order to reduce the risk, you have to amend legislation or create new legislation. And that's how we would operationalize it. So, and if you can show much lower risk, then companies will begin to invest more in your energy sector because they see it as low risk and, they get the return on their investment.
I have just a follow-up question, Larissa. Okay, so like a bit like a sanctioning mechanism. Since we had a panel yesterday on sustainable trade and investment law and the contrast between investment law and climate change law, then my follow-up question would be, how do you make this compatible with the interest of investors, of fossil fuel investors being protected by the investment law regime?
Well, I think we need to change the investment law regime, and that's a major thing that we need to change, because we need to ensure that these companies are doing more, and we need, if they don't want to do anything specifically, let's say, they need to begin to create more environmental funds that can be used to mitigate the damage or contribute to climate adaptation. So there is various initiatives to try and hold companies more accountable. And let's say, there is if you're very interested in this topic, I have a recent paper this year, and it talks about, there's a term that the United Nations are using. They produced a report last year called future-proofing infrastructure. So if you want to send me an email, I can email you the UN report. So it is a major area that is being explored. So if that's part of your own thesis or your postdoc work, it is very exciting, because it is a live issue at the moment. And I've done some early work, but I'll share the article with you if you email me after. So you know, I could talk for another hour on that issue. So a very good question. So thank you.
Thank you. I will.
Thank you to Carlotta for your question, and to you, Professor Heffron, for your comments and considerations. This is definitely a topic that has been under scrutiny for the recent years, and we hope to see more developments in energy law as this topic progresses further. Thank you so much. I'd now like to hand over to our next presenter, Dr. Monika Feigerlova, who is a research fellow at the Institute of State and Law for the Center for Climate Law and Sustainability Studies at CLAS, which is at the Czech Academy of Sciences. She is also an admitted advocate of the Czech Republic. She will be presenting on climate corporate due diligence, reflecting on a draft EU corporate sustainability due diligence directive. Over to you, Monika.
Thank you very much, Larissa, and thank you for the kind introduction and invitation. It's always a pleasure to be in contact with Graz, especially at least virtually, and also to engage with the PhD students. I just, if I may ask, do you see my screen correctly? The presentation?
Yes, we do, and it's in full screen.
Yes, thank you very much. So good afternoon, everyone. I would like to share a few remarks or a few outcomes of my research regarding climate corporate accountability. And specifically, what I will be discussing today is the proposal of the EU on corporate sustainability due diligence and its the climate aspect of it. So I would like to, in the given time, cover three basically topics. First of all, I will start with climate responsibility and whether we see now a trend moving from soft law instruments towards legally binding obligations and the emergence of mandatory due diligence legislation. Then I will discuss the concept of the climate transition plans, which is proposed in the EU Corporate Sustainability Due Diligence Directive. And finally, how the proposal deals, or what is the link to human rights and environmental due diligence in the context of climate change. Climate change is one of the issues that also corporations need to address, not only states. And the fact is that business is behind majority of greenhouse gas emissions. The diagram that you can see on the screen is from the Climate Accountability Institute, and it basically shows that only a handful of companies, which the study calls carbon majors, are responsible more than 50% for total global emissions relating to fossil fuels and cement. So this is a kind of major finding, and maybe as what Professor Heffron suggested, that as regard, because these companies are mostly involved in fossil fuels, that if we can change the conduct of just a handful of the corporations, it might have a significant impact globally. Also the society expects that companies will actively participate in addressing climate change. However, at the international level, we don't have any legally binding obligations upon companies that would impose duties to reduce greenhouse gas emissions. Nevertheless, given that the impacts of climate change violate human rights, I think it is now quite generally recognized that climate change is considered a human rights issue, or at least we can see that in reports of the Intergovernmental Panel on Climate Change, also in the reports of the UN Human Rights Council. And from this perspective, we actually somehow interfere with the business and human rights agenda. And also we can see it in the climate change litigation that human rights law instruments are put forward to companies trying to make them accountable for their business and for the impact of their business on climate. As regards the business and human rights agenda and how it is used also in the context of climate change, then we can also observe quite significant developments since the last decade. And even here, from purely voluntary standards, we moved towards to responsible business conduct, which is not considered non-binding, even though the instruments that regulate it are non-binding. And also we can witness that there are legislative measures. So the trend from soft law to hard law is already visible, and it started with the obligations as regards disclosure and transparency. So, for example, the non-financial reporting that is already for a couple of years in Europe. The main representatives of the soft law instruments that I have in mind are the UN Guiding Principles on Business and Human Rights. It's the United Nations framework of the Protect, Respect and Remedy, and the OECD guidelines on for multinational enterprises. So basically, based on these instruments that somehow clarify what is expected globally from companies with respect to protection of human rights and their duty to respect human rights, which is achieved by conducting or putting into place due diligence processes. So here the due diligence process, what I mean is a risk-based process by which the company manages the risks, but the risk that are focused on the people. So it's not in the traditional way that that would be a risk for the company, like legal or financial risk that the company tries to manage, but it's the risk of its activities on people or on stakeholders which could be concerned. And based on this basically regulation, the EU and also other countries in recent years started to adopt mandatory due diligence legislation. And I have to say that the proposal that I will try to discuss today of the EU is the most advanced one as regards the scope and what it aims to cover, and in terms of the description of the steps of the due diligence process. So below you can see the proposal of the Commission that deals with the corporate sustainability due diligence. I will still come back to that. The overarching theme or the question that I'm trying to ask about this proposal is basically how to hold companies accountable for their climate impacts. And if we want to transfer the due diligence obligations or we want to make them legally binding, obviously we need to speak about liability and sanctions. So the specification or conceptualization of the corporate climate responsibility then poses several points. And the first point is about whether climate change impact assessment is part of the human rights or environmental due diligence which are envisaged in the proposal. Then what is the legal nature of the climate transition plan that certain companies would have to adopt, whether in itself it's a binding obligation and can be enforced by third parties, and how actually the proposal is then aligned with the UNGPs and the OECD guidelines. And this is quite important in a way that these guidelines, as I already mentioned, were put forward to companies in climate change litigation. So even though they themselves are non-binding, they still were used by petitioners or complainants in several ways. And I think the primary example is the Shell judgment in the Netherlands, where the UNGPs were used through Dutch law, but there was a reference to this instrument as a recognition that it is expected from companies that they will conduct human rights due diligence, and that actually if they adopt or prepare climate plans, that there should be the due diligence dictates that they should be aligned with the Paris Agreement. Another example is the carbon majors inquiry, which was before a non-judicial organ in Philippines, and here actually the petitioners fully relied on the UNGPs trying to open investigations into violation of human rights that were basically caused by climate change, and for which were alleged to be responsible carbon majors. Again, these 100 companies active in fossil fuel and cement operations. Another example from the OECD guidelines is even more interesting. The OECD guidelines compared to they also are based on the UNGPs, but they extend the obligation of due diligence to other areas, not just to human rights. So even to environment, corruption, and other aspects. So actually these guidelines, they contain a chapter that is devoted to environment. But also what I want to highlight is that none of these documents actually expressly mention climate change. So that's why it's, I think that it's actually tremendous development that these instruments are being interpreted as trying to somehow establish climate corporate responsibility. And under the OECD guidelines, there are national contact points, which actually I think are mostly part of government or ministries, and are responsible for effective implementation of the guidelines in the given state. So they don't have any decision-making power. Their opinions are not binding, but it's interesting to look in the case law of the NCPs and to see how actually the governments interpret the OECD guidelines in terms of the obligation of multinational corporations. And here I would like to highlight a case which was assessed by the Dutch NCP, and it related to, it was complaint against ING Bank. And actually the NCP concluded that companies are expected to carry out a due diligence process with regards environmental impact, including climate impact. And also they added that this applies not only to the negative emissions of the own activities of the company, but also to the value chain. So here we can see that actually the NCP, even though OECD guidelines do not mention climate change, they were able to subsume the climate impacts under the environmental due diligence. And coming from here, I would like to now introduce what the EU proposal is about, because obviously the obstacle or the shortcoming of this soft law instrument is that if we want to somehow establish corporate climate responsibility, the scope or the contours of the duties will be always unclear. So if we want to make the obligations binding by law, then obviously we have to be more specific. And so here comes the EU proposal. The situation is still unclear because we have a number of texts on the table, and obviously it is not still an approved proposal. It is a draft. And so we have a EU Commission proposal that was released last February. And the European Parliament, the rapporteur for this directive, Ms. Lara Walters, she prepared a report in November 2022. And then in December 2022, the Council, so it means the member states, they also expressed their position in the general approach. And I will be mostly speaking about these, like comparing these three instruments. But the recent development is that actually last month, the legal committee of the European Parliament approved a text, which now is waiting for the voting in the Parliament. So, and the report was published just 2 weeks ago. So I will just make some remarks, but it's not fully reflected in this presentation. And the last document that I would like to mention in this context, and which is in my view very important, is the EU Corporate Sustainability Reporting Directive. And this is a document which is already in force, and we will see the reports on sustainability, I think, starting from 2025. Also one remark as regards due diligence, because obviously that the proposal was quite discussed even in media, and the due diligence process was criticized that it should not be subject to legal obligation, that it's not fit for that. But however, if we look into other pieces of EU legislation, we can actually see that there are already other regulations which contain or which work with the concept of corporate due diligence. For example, the conflict mineral regulation or other regulations which are very interesting and also are not approved yet is the deforestation regulation and the regulation regarding batteries and waste batteries. So let's look at the proposal. As I said, there are two main aspects of it. If we look at the subject matter, what actually the proposal tries to address is the human rights and environmental due diligence and liability for violations of these obligations. And then, as you see highlighted in the red box, is the obligation to adopt a plan, so-called climate transition plan. And this is an addition that was added by the Council to make it clear that actually there is a separate self-standing obligation in the proposal that deals with combating climate change. And in this aspect, I have seen some comments that actually the proposal goes beyond the UNGPs in this way, because UNGPs, as I said, do not mention climate change, and that here we have a self-standing provision. However, if we look into the details of the provision and of the whole concept, the added value of how the proposal addresses climate change is questionable, at least. So the self-standing provision is Article 15, and it is entitled Combating Climate Change. And as you can see, the member states are obliged to ensure that companies adopt a plan to ensure that the business model of the company is compatible with the transition to sustainable economy and with limiting the global warming to 1.5 degrees Celsius in line with the Paris Agreement. Then you can see that the plan actually there is not much about it, that should, based on reasonably available information, should only assess to what extent the climate change is a risk, or the activities of the company impact climate. So it's the double materiality assessment, meaning that the company has to assess how climate change can influence actually its activities going forward, but also so what is the risk, and also and mainly how the activities of the company impact on climate. And so there are not many details about the plan. And if actually the company concludes that the risk or the impact is principal, then in such situation, the plan has to contain the emission reduction objective. Here I prepared a table that, as I said, deals with the three documents, but the middle column is the report of the rapporteur. It's not the final text that was approved by the legal committee 1 month ago and released 2 weeks ago. But when I looked at it in the morning, it actually is heavily, as regards climate at least, it is heavily relies on this document. So I think in principle it still works. So as we can see, the first point is about what is actually the content of the obligation. And here we can see amendments from the original Commission proposal regarding the adoption of a plan towards, if you look at the Council, that it shouldn't be sufficient. This is important for the then consequences if the company fails to meet the obligation. So it should be not only adopting the plan, but actually implementing it and also reflecting it in the relating financial and investment plans. This is, I think, will not be controversial. What will be and require more discussion is actually what the plan should contain. And here, one big remark is that actually, and it was the biggest comment of the Council, is that the plan actually should should be aligned with the Corporate Sustainable Reporting Directive. The directive, as I mentioned, is already in force, and it does contain quite detailed provisions. It doesn't call it climate transition plan, but I think plan to mitigate climate change. And obviously, to achieve consistency and effectiveness, these two documents should be aligned. So these were the main comments from the Council, and we see that in addition to just the Paris Agreement goal, temperature goal, it added the objectives of climate neutrality based on the EU climate law. And also, for example, exposure to coal, oil, gas related activities. This is really copy-paste from the Climate Sustainability Reporting Directive. The Parliament actually wants to go even further, how you can see it in red, it actually does reflect some details that are already contained in the reporting standards that have been in the meantime prepared, and which will be binding upon companies that will report according to the Sustainability Reporting Directive. What is interesting about also the content of the plan, or what is raised in literature, is two things: whether actually the objective of limiting global warming to 1.5 Celsius is a relevant or appropriate objective for a corporation. It's true that it is transferred from transposed from the Paris Agreement, but here we have a different addressees who should be held liable for failure to adopt the plan and implement the plan. And also the critique is that actually based on science, there will be already overshoot of this temperature goal, but in that case, the companies still should be obliged to reduce greenhouse gas emissions. So that's an interesting point, how to actually formulate the objective, the goal. And also it's the second related question is that it suggests that it's obligation of result, because even though due diligence process is obligation of conduct, but here, and it's typical with climate change, even in climate change litigation, we tend to see that actually also the adjudicative bodies tend to impose obligation of result. Also from the suggestions for the Parliament, we can somehow see that or to address the second question, which is a major question, like when a company is then counting its greenhouse gas emissions, what activities is to be considered. So this is the reference to the scope 1, scope 2, scope 3 emissions. And very simply put, if we think about a car manufacturer, for example, the question is whether such company will include in their greenhouse gas emissions also the emissions from the use of the sold cars. And it's true that with respect to many companies and also financial sector, a majority of the emissions are actually in the scope 3. The difficulty is that they are difficult to measure. But here I tried to, at the bottom of the slide, I tried to copy the last text that was approved actually by the legal committee of the European Parliament. And here it's the recital 50 of the directive, which is basically an introduction about what is the aim of the climate transition plans. And here we can see two interesting findings. First, that actually scope 3 emissions are dealt separately from scope 1 and scope 2, and it says very relevant. So I believe that there will be discussion about the inclusion of the scope 3 emissions. But on the other hand, the last sentence says that actually, and this is very important, that each company actually which is subject to the regulation will have to set an emission reduction target unless it proves that actually it's irrelevant for their activities. And this is a total opposite position from the text that was proposed by the Commission, because it actually anticipated that some companies do not even need to set the greenhouse gas emission target if the risks or the impacts are not principal, which is very strange, because you would expect from a mandatory due diligence legislations regarding climate that you will have something on reduction of greenhouse gas emissions. I have already said that I think the main point for this document must be to be really aligned with the already effective corporate sustainability reporting directive. Otherwise, it opens the door for greenwashing and also for inconsistency. And it's kind of strange, because the part of the due diligence process is to disclose the how the company conducts the due diligence and what are the findings. And obviously, the end product was now adopted by the Commission, by the EU earlier. So, and is quite detailed. So there is no, I think, in my view, even though the scope of companies that are subject to a reporting directive and to a due diligence directive are different, there is no, in my view, reason why the regulation should differ in terms of the required details. And finally, what I would like to address is this is the most, in my view, controversial aspect of the Commission proposal, because as I tried to illustrate at the beginning, even the soft law instruments were able to find actually that there is a duty of company to conduct due diligence that takes into account climate impacts. And suddenly here, actually, the Commission proposal does not include climate impacts in the environmental or human rights due diligence. And it's not only a way of that, maybe we should interpret it differently, but actually from the text, it is clear that the Commission planned that after several years of practice of the directive, it will reassess whether to include adverse climate impacts into the environmental due diligence. And the big question for me is how this then is complied with the UNGPs and the OECD guidelines, and whether it is a setback towards these standards, even though they are non-binding. They were able to somehow develop a quite interesting case law. What I can say is that the European Parliament obviously tries to revert this and tries to subsume the climate change into the environmental due diligence. So we will see whether it will be approved. Also, the scope of application, interestingly, the provision on the self-standing Article 15 on combating climate change has its own and narrower scope of application than the entire sustainability due diligence directive. Again, I think the estimates on the entire directive were that it would catch about 13,000 EU companies and 4,000 non-EU. So you can see that these would be really only very, very large companies. And in the remaining time, I would like just point two things about the enforcement. Obviously, the big question is, and also for any interested party, whether the plan makes any meaning in a way that NGO, shareholder, or other interested party can actually challenge the climate transition plan, like in the same vein as the Shell climate plans were actually challenged in the Shell judgment. The directive does not actually give quite ambitious answer. It anticipates that each member state will have to appoint a supervisory authority, which would actually supervise the compliance of the obligations in the directive, and that especially is with respect to the due diligence. But if climate is outside the due diligence, it does not add anything, but it also should supervise the Article 15. And then the question is, what is the power, and whether actually the Council proposal was that the supervisory authority will just check whether a company adopted a plan, so it wouldn't be able to review the content. So this is also, I think, a big question mark, how whether the provision have any teeth. Also, the directive itself does not implement any sanctions. It will be up in the member states to adopt administrative sanctions. As regards private enforcement, the directive contains an article on civil liability, but again, these articles are fully applicable only to the due diligence, the human rights and environmental due diligence. So again, if climate is not part of the due diligence, there is really nothing in the directive or for the member states to implement. On the other hand, the directive will not lower the protection that is already present, this in the EU member state, meaning also in national legislation. So, for example, the petitions or the actions that were possible in the Netherlands will still be possible. It will not be concerned by the directive. And also the directive is, because it's a cross-sector instrument, the specific sector regulations, which are more specific, will have precedent. And the last point is that also with respect to the climate change is one of the aspects that will be part of the assessment of duty of care. So if directors decide about investment decisions, etc., they should also implement under considerations on climate. There was a proposal in the Commission, even proposal, but was deleted in the Council proposal that actually part of variable remuneration of directors should be linked to the fulfillment of also of the climate transition plans. And it was then reconfirmed by the Parliament. It's back in the play. So we will see whether actually at least this will somehow be approved. And I will stop here, and I will be then looking forward to any questions afterwards. Thank you very much.
Thank you so much for that presentation, Monika. It was greatly appreciated, especially in a time where corporations should be taking on more responsibility with regards to their climate commitments. It's great to see the research that's being done in the field of due diligence, and I'm sure that there's a lot of questions that we can address in the question and answer session. For our next presentation, I would now like to hand over to Carlotta to introduce our next presenter. Over to you, Carlotta.
Yes, thank you. So our next presenter is Lea di Salvatore. Lea is a legal researcher at the Columbia Center on Sustainable Investment, where she focuses on environmental and climate change law. Previously, she has been teaching and researching at the University of Nottingham, and she has worked extensively on the legal barriers to phasing out fossil fuels in the Global South, topic on which she will be talking about today. Over to you, Lea.
Hi, can you hear me? Yeah. Okay, I'm just going to share my screen. No, I'm not sharing the correct screen, sorry. Can you see the? No, I don't think.
Not yet.
Okay, you should be able to see it now.
Yes.
Okay. Okay, I think that should be all good for now. Okay, so yes, good morning, good afternoon to you all. It's a pleasure to be here. So thank you very much for inviting me. Thank you, Carlotta. And yes, I as Carlotta was saying, a legal researcher at the Columbia Center on Sustainable Investment. And I focus on phasing out fossil fuels in the Global South and the barriers phasing out fossil fuels. Today, I want to focus on specifically the role of international investment law in protecting fossil fuel investment and how this entrenches the just transition in the Global South. So I will be quickly be talking about phasing out fossil fuel, what it is and what it entails, especially for the Global South. And I will then give a brief introduction on international investment law that I know you already had a presentation from Professor Vermeglia yesterday. So I'll be very brief on that just to recap a little bit and give a few information that are essential for my presentation. I will then make consideration on international investment law and the just transition, and then make some considerations and recommendation. So first of all, we need to understand the science. As Professor Heffron said before, often lawyers like work in silos, and not always there is a great understanding of the science behind the law. So fossil fuels, first of all, fossil fuels are the biggest contributors to climate change. It's a very well-known fact. And in the latest IPCC report, the IPCC state that in 2019, approximately 79% of global greenhouse gas emissions came from the sector of energy, industry, transport, and buildings together. And that means mainly fossil fuels. And they also add that the largest share and growth in gross greenhouse gas emissions from CO2 emissions are from fossil fuels combustion. And so fossil fuels, we're referring to any coal, oil, or gas projects, and that is from any type of so from the extraction to the consumption of these fuels. So now, given that we have already reached 1.1 degree of warming, there is a scientific consensus that to stay within 1.2 degree of warming, fossil fuel must be urgently curtailed. And that means that we need to phase out emissions and production. So emissions reductions are more mitigation actions that are taken in the global north, where we consume fossil fuels mainly, where such policies, such measures are more, for example, one of the emissions could be, for example, efficiency of buildings and things like that to really reduce emissions. So, for example, also diminishing the pool of cars in one's country, and those are the types of actions. When we're talking about production measures, we're more looking at the global south and also the global north, but we're talking about the supply side mainly. So all these actions that are aim at curtailing the production of fossil fuels. And this is exactly where I want to put a little bit more attention, because production of fossil fuels in the global south can become very problematic under international investment law circumstances. So fossil fuels must be phased out. And the assessment reports, the 6th assessment report of the IPCC and the International Energy Agency net scenario are very clear. To stay within the Paris Agreement objectives, we need no new fossil fuel project can be developed. So there is a general consensus that according to the 1 and 1.5 and 2 degree pathway, the world must decrease global oil, gas, and coal production almost entirely. And that means that we need to rescind existing licenses for exploration, and we should just end exploration licensing. Basically, we have a set amount of carbon and greenhouse gases we can emit in the atmosphere to stay within 1.2 and 2 degrees of warming, that are called the carbon budgets. And we are already more than half of this carbon budget for 1.5 and 2 degrees, and all the existing resources would really exhaust these carbon budgets very, very fast. And moreover, we also need to phase out existing projects, and we need to transfer investment from fossil fuel industry to renewable energy projects to close the investment gap. The investment gap currently stands at $450 billion annually. In fact, although there is like scientific agreement on all these measures, and we have an urgency to do so, trends are not looking very good. According to the International Energy Agencies, the recent trends are far from enough to bring a lasting reduction in emission. In fact, for 2018 and 2019, out of the $1.8 trillion that were invested in energy, more than half were still going towards fossil fuel investments. And only 20% of this number was going to low carbon investments, which is a little bit more than a third of the total expenditure for fossil fuels. And moreover, projections for the futures are even more alarming. So the production gap report released every year by the Stockholm Environmental Institute estimates that by 2040, countries' plans and projections show an 190% more fossil fuel extraction than would be consistent with a 1.5 degree pathway, 190%, and 89% more than it would be consistent with the 2 degree pathway. So we have a little bit of a problem here. And in this context, fossil fuel investors play a very crucial role. In fact, 45 to 50% of all oil and gas industrial projects are financed by foreign companies, and 40% of power generation projects are also financed by foreign investors. So that means that this great share of investors that are foreigners or for using a foreign subsidiaries, because mega corporations have different branches, generally can have access to a higher degree of protection for their investment under international investment law. And international investment law is formed by various instruments, many international investment agreements that typically include special treatment provisions and provision on investor state dispute settlement. So these provisions that you probably, Professor Vermeglia talked about yesterday, I will be very brief, can also be found in the Global South in national legislations and investment contracts. And one of the most important mechanisms that is granted by these provisions is the investor state dispute settlement, or ISDS, because as you saw yesterday, it's the enforcement mechanism of international investment law. And this system allows investors to sue governments over measures and actions that allegedly violate the standards of treatment granted to their investments. So basically, investor can seek compensation for lost profits or even future expected revenue in certain cases for measures adopted by the host country. And there has been an increase in cases in the last decades, and especially in the last years. There has been a very steep increase in cases brought to international investment tribunal. Just very quickly, there's several types of protection that are afforded by international, that are granted by international investment law to foreign investors. The main provisions are direct and indirect expropriation, national treatment, most favored nation, fair and equitable treatment, and minimum standards. So just to be very, very quickly on these provisions are usually they are very, very vaguely worded, and there is huge debate around their interpretation, because the interpretation made by arbitral tribunals can vary consistently from case to case, and it's very very arbitrary. Like they usually use different they can freely interpret these type of provisions according to the case. So this type of this, especially the interpretation of this provision, can become very spinous, and especially when we have particularly vague provision like the fair and equitable treatment, which is an absolute standard of treatment that states the treatment to be accorded in terms of in absolute terms. So foreign investors are granted fair and equitable treatment in general, and this is a very vaguely worded provision. And for example, within this fair and equitable treatment, claimants have started to claim that if their expectations were being breached by a state measure, that could be a breach of the fair and equitable treatment. So, for example, in the case that a company makes an investment into a host country and suddenly the legislation changed for some reason, whether it's legit or not, but this measure curtails the future profit or the expected profit of this company, it can sue the country under fair and equitable treatment, because such provision has infringed its legitimate expectation. So what the company was legitimately expecting from these in revenues from this investment. So and you can understand that how these provisions, by being vaguely worded and vaguely and interpreted very creatively by arbitral tribunals, and can bring a very hard layer of protection to foreign investors. Moreover, you have also other type of protection that are also encountered in contracts. Those contracts, in these protections, stabilization clauses are in contracts mainly in global south countries. I have never encountered stabilization clause in contracts in the global north. You have different types of stabilization clause, that you can have general stabilization clause that mean that provide that during the duration of the contract, the environment in which the contract was concluded has to remain the same. So it's a general stabilization clause, and you have more specific stabilization clause that can be fiscal stabilization clause, regulatory stabilization clause. That means that the legal regime or the fiscal regime has to be maintained the same for the duration of the contract, or if any measure is adopted, that measure will change the regime of the contract. That measure will not apply to the contract. So if you're looking at fossil fuel investment, we are looking at contracts that are like 25, 30, up to 40 years. And that can necessarily cannot necessarily would be in conflict with the evolution of the law, especially in climate and environmental measures. So where do we find these specific provisions? I said already, in contracts, we have mainly bilateral investment treaties, treaty with investment provision that are For example, the most famous one, we have CETA and NAFTA, that is now the USMCA. And we have multilateral investment agreements, specifically the Energy Charter Treaty, which is a multilateral investment treaty that grants special protection to foreign investors, and it directly covers fossil fuel investment. Moreover, and those are specifically in the Global South, we have national laws and investment contracts. Berge and St. John in the research have found that 74 countries have adopted laws granting special treatment to foreign investment at the national level. And they have also found that these countries have adopted these laws after a capacity building and discussions with the World Bank. Just a quick note on this, the World Bank is also where the International Court for the Settlement of Investment Disputes reside. And in investment contracts, we have concession contracts in the extractive industry that are concluded by host country investors that include special provisions. As I was saying, they can grant direct access to investor-state dispute settlement, and they can also have certain stabilization clause. Moreover, a recent trend has been that foreign investors are increasingly inserting, of course, with the consent of the host state, provisions that are generally encountered in international investment agreements. So fair and equitable treatment, direct and indirect expropriation. Again, I've found this provision, this clause only in investment contracts in the extractive industry in the Global South. So these special treatments and this special provision can have conflicting objectives with public policies, especially climate and environmental ones. So Jorge Viñuales has grouped climate change measures in 3 categories: cap and trade measures, command and control regulation, and differentiation measures that can include carbon tax and duties and climate subsidies. And these measures can, of course, entail the prohibition of certain activities, the imposition of energy standard, and the withdrawal of rights held by economic operators in carbon-intensive industries. And all these measures can be challenged by foreign investors at breach of substantive investment protection. So, for example, the decommissioning and reduced utilization of existing fossil fuel installation, as suggested by the IPCC, might be challenged by foreign investors at breach of, for example, of substantive investment protection, and they can claim that this can amount to indirect expropriation, for example. And yes, there is these climate objectives can be highly conflicting with the international investment law. I will not stop. I will not continue on this because I assume, and I know that I'm sure Professor Vermelha yesterday talked extensively about the conflicts in between international investment law and climate change measures. In fact, certain cases have been already surfacing on that regards climate change measure. And I know that you said earlier that you already talked about Rockhopper, so I will skip on that. Just here to say that in general, there has been a raise and a raise in the amount, an increase in the amount of investor state arbitration against climate measures. Here I have made a list of the one we know about, and just to give you an idea, in March 2023, a US-based company, Ruby River Capital, has initiated the next arbitration against Canada, invoking the NAFTA legacy provision of the USMCA treaty after the Quebec authorities decided to deny an environmental permits for the project, claiming that it would have significant adverse effects on greenhouse gas emissions. And they are claiming the moderate sum of $20 billion in compensation. So these, as you can see, are all in the global north. You see Germany, Canada, USA, Italy, the Netherlands, Canada. And those are the ones we know about. But actually, there are a lot more arbitration that have been initiated against environmental measures already, and a lot of these arbitrations have been initiated, for example, in Latin America. Ecuador, for example, has received a lot of cases that are related to environmental concerns. And so these claims, as I was saying, are initiated against countries that are in the global north. What happens when these claims are initiated against countries in the global south? Because here we are talking about like this claim against NAFTA, as against Canada was $20 billion, but the claim against Italy and against the Netherlands altogether were $1.4 billion, and they weigh heavily on the public budgets, even of the global north country, let alone global south countries. So to which extent ISDS claims are expected to challenge climate change measures, and to which extent they can pose a serious threat to the just transition. So to answer this question, I had a look at how fossil fuel companies rely on international investment law, and specifically on investor-state disputes settlement system. So I looked at the number, and first of all, having initiated almost a fifth of all investment arbitration in my database, the fossil fuel industry is by far the most litigious industry under international investment law. So it has undiscussed leadership, and it outnumbers by far any other sector. Also, the great majority of claims within fossil fuel arbitrations are related to investment in the upstream sector. So this is very important because these litigation concerns projects that are for the exploration and extraction of new fossil fuels, the ones that we have to leave underground, and they cannot be extracted if we want to achieve net zero and by 2050, and if you want to stay within the 1.5 and 2 degree warming targets. So these are particularly critical cases, and half of these cases are initiated against upstream, initiated in the upstream sector. Lastly, I found that of the cases that the tribunal, where the tribunal reached an award, and the award was disclosed, the decision was taken in favor of the investors in 72% of the cases. So, and this is important also to note that this is only of the cases that we know about. These are only the cases that have been disclosed, because there is a great and widespread lack of transparency in this sector. We often, more than often, awards are not disclosed. We don't even know in certain cases, unless they are the claims are lodged at ICSID, that has a transparency rule that it at least put the claim in the database with the name of the parties and the instrument invoked, so what type of treaty or contract has been invoked. Other than that, besides ICSID, the other institutions do not have the rule of even putting it in their database to signal to the public, the greater public, that this case is happening. So a lot of cases actually happen under the radar, which is extremely problematic if you want to look at accountability, and this is even more so in contract cases. Contract cases are the ones that are the least disclosed. And if you consider that a lot of cases in the global south, given that all the provision they put in the fossil fuel contracts in the global south, and most of them are not disclosed, it's very hard to get a clear picture of what is actually happening. On top of that, the costs of litigations are extremely high. So as you can see on the left-hand side of the slide, you have the 10 largest amounts ever awarded in investment arbitrations, 8 are related to fossil fuel investment. And as you can see on the right-hand side of the slide, the amount awarded in fossil fuel arbitrations are incredibly higher than in non-fossil fuel arbitration. They are 5 times the amount awarded in non-fossil fuel arbitration. So the costs, and these are only the amounts that have been awarded by the tribunals. On top of that, we have to add the applicable interest, the cost of the tribunals, and the legal fees. So we are looking at extravagant amounts of money that are already that are enormous, and it would be very hard. It's very hard for global south country to face this type of claims, and they can't take the risk of having these type of claims, economically speaking, to face this type of claims. On top of that, so they weigh heavily on the public pockets of the host countries, but they bring great rewards to the carbon majors. So a report from Climate Institute estimates that carbon majors, which are the companies, those are the top 12 per amount of awards. But the Climate Institute estimates that these carbon majors are responsible for 71% of global industrial greenhouse gas emitted since 1751. And among them, 25 are responsible for more than half of global industrial greenhouse gas emissions. So all these that you can see listed here are carbon measures, and they have initiated an enormous amount of claims, because although the numbers seem low, 7 arbitrations is incredibly high in investment arbitration because of the costs and the duration of these processes. And in total, they have been awarded already $19 billion. And this is only the amount we know, because as you can see on the last column, a lot of them are unknown because the amounts have not been disclosed. And I can tell you that ExxonMobil is the only company that I know of that has its own department of investment law within its legal team. And it's the only company that has its legal team specialized on investment law. Usually these investment arbitration are they're usually in this investment arbitrations company rely on external and extremely specialized law firms. And so this says a lot. The fact that ExxonMobil has an entire department on investment arbitration says a lot about how ExxonMobil relies on this system. So going forward and coming to the geographical disparities of this system. So here you can see that in the top chart, you have investors' nationalities. So how many claims have been, the percentage of the claims initiated by investors from high-income country, which is nearly the total, it's 92%. And on the bottom chart, you have the respondents. So the respondent countries and their income level. And you can see that it varies, but mainly the claims have been largely initiated against upper middle income countries and lower middle income countries. And these classifications are the OECD classification. So for high, upper middle, and lower middle and low income. Just to give you, give you an idea, the upper middle income countries, their gross national income goes from $4,000 US annually to $14,000 US annually. So it's not an enormous amount of money. So continuing here you can see very clearly where the claims come from and where they are directed. So United States and Europe are definitely in the lead with as investors, and United States particularly. And you can see where they are going, especially against Latin American countries. And you also have India, Kazakhstan, Ukraine, Bangladesh, for example, has received a lot of claims, and Egypt. So what is interesting to note as well is that in recent years there's been a rise. So in the first graph, in the previous slide here, you can see that low-income countries have a relatively low share of ISDS, receive a relatively low share of arbitrations, only 11%. But what is very interesting is that in recent years, there's been a rise in ISDS initiated against low-income countries, and these cases are mainly contract-based. You can see here 56% is the, sorry, I forgot to put the legend, but 56% is the share of arbitrations that are initiated based on a contract. And given that a lot of these arbitrations are not public, this is a very large underestimation. It's probably the amount of claims initiated against low-income countries is probably much larger. In comparison, contract-based arbitration in contract-based litigation in general constitute only the 7% of the total arbitration initiated. So there is really a large, the majority of the claims initiated on low-income countries are based on contracts. And it is, of course, there is a reason why, because having these provisions directly in contract, it's much better for the investors than having to rely on international investment agreements. And for example, having the stabilization clause gives them really carte blanche, and they can really, anything that can minimally curtail their profit or change the regime in which the contract was concluded. So for example, one government made a certain regulation at the time for oil and gas, and the government after decided that that was not, could have a repercussion on the environment, and changed the legislation. Either it doesn't apply to the specific contract that was in that was signed and entered into force in that specific regime, or if it does, there is a very likelihood that if it has a stabilization clause, the investors will bring the country to arbitration. So as we saw earlier, the costs are incredibly high, and therefore they might impede, block, and roll back any measure in the global south. Like here, we've been talking about climate change measures, but the reality is that any type of measures really will be that can minimally curtail the profit might be rolled back and or fought against by the investors in arbitration. And the costs are incredibly high, so the position of low-income countries is really in a really great disadvantage. So recent research shows that the global action on climate change could generate an upward of $340 billion in legal claim from fossil investors. And this is an extremely conservative estimate. Extremely, Kailath and Hara said it many times, this is a very, very conservative estimate. And you can see that the 5 countries with the greatest potential loss from ISDS are Mozambique, Guyana, Venezuela, Russia, and United Kingdom. So besides, say, the UK and I think also Russia, these countries the stakes are really high for Mozambique, especially Guyana, Venezuela, because $31 billion for Mozambique is incredibly high. And most of my research has been focused on Mozambique, and I can tell you that this estimate is particularly conservative because the number of possible liability is likely to be incredibly higher. Just to give you an idea, one mega project in Mozambique of liquefied natural gas is now being valued and worth $30 billion US, and this is one mega project. There are many others mega projects. In comparison, Mozambique ISGDP was nearly $18 billion US in 2014. So in this case, you can imagine how such protection can pose a really great burden on these countries, and they will never adopt any legislation that might go against the interests of this industry. I can also tell you from my research that nearly all available contracts grant access to investor-state disputes, and they also present all the provisions that are usually included in international investment agreements. So they present direct and indirect expropriation, fair and equitable treatment, giving even more leeway to the investors. And nearly all the contracts present stabilization clauses as well. And they grant direct access to ISDS. And lastly, these mega projects in Mozambique, the gas mega project, for example, the one that's worth $30 billion US, could have a massive impact on the climate. In fact, a recent report estimates that this could emit in between 3.3 and 4.5 billion tons of carbon dioxide equivalent over the project's life cycle, which is more than the combined annual greenhouse gas emission of all the 27 European Union countries. So the carbon budget cannot accommodate this amount of greenhouse gases. Yet Global North corporations are developing this type of projects in countries like Mozambique with very, 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 very favorable conditions. So does ISDS constitute a risk for the just transition? The answer is obviously yes, it does. It offers a tool to fossil fuel companies to fight regulatory reform that includes also environmental and climate change measures, but in general, that just offers them a tool to repeal any type of measure or to fight against any type of measures. And they have demonstrated over the years to have the power, the means, and the will to recur to ISDS in any circumstances. The ISDS, the system, okay, the international investment law developed with the oil industry. It developed in the 70s with the first oil arbitration with this one sole arbitrator. So it is very much entrenched, is very much interlinked with the oil industries. So let's even consider, as some say, that this poor corporation needs compensation for their lost profit. Fair. I do not agree with this, but if they need compensation, if you agree on the fact that we should give this corporation some sort of compensation, even if, is it really the role of investment tribunals to decide on this type of compensation that do not make any sort of environmental and climate consideration or even human rights, forget human rights considerations? They only look at the economic protection of the investors. So I don't think this is, even if we want to consider that they should have some sort of compensation, it's not the place for them to have it. So just to conclude, that shows that low-income countries that are dependent on fossil fuel industry for their revenues must really be at the center of the climate talks. Like we need to phase out fossil fuels, and we need to, as Fergus Green say, cut with both ends of the scissors. That means not only emissions, but also supply side. And even if we were working only, even if we were only considering emissions, it is unfair to consider only emissions, because emissions are going to be, so the demand side and emissions and the demand side measures will be mainly be adopted in the global south. That means that all these investment made in the global south to get revenues for their development will no longer be profitable, and they will be left with infrastructure and extremely and locked into a carbon cycle and carbon entanglement. So these countries should really be at the center of the climate talks, and especially the supply side, which is often overlooked, and it's often underlooked, and especially when it comes to the global south that are generally not concerned with mitigating emissions. They should be at the center of the climate talks, but they also should be at the center of other negotiation process and other talks. For example, international investment arbitration or the ISDS reform process is completely monopolized at UNCITRAL, completely monopolized by global north countries, and they often do not participate. Low-income countries often do not participate for constraints, for economical constraints, lack of capacity, and so on and so forth. So really, we need to pay much more attention on low-income countries that are sitting on large fossil fuel resources. Needless to say that we need to reconfigure international investment agreement and ISDS as a whole. We should really terminate, withdraw from existing international investment agreements that contain ISDS, not only for climate purpose, but in general for because the system is particularly unbalanced, and even more so when these type of agreements are not aligned with climate objectives. Another option, a little bit less drastic, could also be to suspend or otherwise exclude ISDS for all fossil fuel investments, and that can be made at a multilateral level, which is also an important, would be a considerable challenge to adopt such agreement. But it can also be agreed within bilaterally or multilaterally within certain international investment agreement to exclude fossil fuel investments. And also there is an important need to modernize old-fashioned and widely interpreted investors provision protection. There has been some movement. For example, the new India bilateral investment treaty has put more as defined in greater detail what those provisions entail, but this is really not enough. Like, we need more, we need a better definition, and we need more rules for interpretation. Because as you saw yesterday with Professor Vermeglia, for example, there in the rock hopper case, there was an environmental exclusion provision in the treaty that was completely bypassed by the tribunal, or weirdly interpreted by the tribunal. Lastly, government also should reassess ISDS and other relevant provision in national investment codes and investment contracts, because when you have ISDS in a contract, you have access to the same type of mechanism, and these tribunals apply the same type of reasoning and rules. And for example, for calculating damage, they often use discounted cash flow for investments that have not even started yet, or they use other type of calculation that have been considered to lead to extravagant and amount of money. So we need government should reassess ISDS and other relevant provisions in their national investment code and investment contracts. And we need more transparency and more transparency in this system. There is just not enough transparency. Lastly, I've talked about government should reassess ISDS and all of relevant provision in their investment contracts, but given the capacity of low-income countries, it's going to be very, and their bargaining power, it's going to be very hard that this government will renegotiate their contracts. This is why, and these companies are all from the global north. So this is why the global north has to be absolutely leading into tackling this type of protection for that protects supply side in the global south. It's the responsibility really of the global north country that has developed this system and now needs to really redress it. And so thank you very much. I look forward for the next presentations.
Thank you so much, Lea. That was really, really eye-opening and insightful, as well as frustrating, I think. But I'm looking forward to the Q&A to bring together all these inputs from today. And in the meanwhile, I will introduce our next speaker, that is Professor Dagny Celis Toledano Cordero. She's a professor of environmental law at the University of Havana, Cuba, and currently a visiting fellow here at the University of Graz. I'm leaving the word to you, Professor.
Wow. Good afternoon and good morning for everyone. So it's a pleasure to be here. As you can imagine, when you read the title of my presentation, I'm going to share with you some the reality from Cuban in issues of climate law. I repeat, it's a pleasure to be here, and I hope that you be interested in my presentation. We can change the slide. Maybe Larissa can help me, please. Wait a minute, please. Okay, everything fine now. Sorry. As you know, the climate law is a reaction to scientific alarm about its degradations. Since 19, the United Nations are increased the climate-related activities and environmental issues for climate change as disclosed a truly global dimension. Need of protecting the Earth's climate for a benefit of humankind is a reality. That is why the two major challenges of our times are the necessity and requirement to protect of the human being as well as for the environment. Environmental law in general, specifically climate regulations, have left a mark on international law because it has broken the dynamics of international law as an expression of the will of the state. But its norms are an expression of its national will supported by other international actors, such as NGOs, that they have played an important role in the development of the different international agreements. As a result of that, there are a lot of number of international legal instruments for the protection of the environment enforced today, including the legal regime of climate. That's international climate regimes. It includes 4 important conventions: Convention on Climate Change that was adopted in 1992, Kyoto Protocol, Copenhagen Accord, and Paris agreement. In the case of Cuba, Cuba is signatory of a lot of conventions and other instruments on environmental matters, including the Convention of Climate Change, Kyoto Protocol, and the Paris Agreement. Complying with its commitment, although in some times and some cases, it has been limited by our economic situations. In the slide, you can see those that we consider the most relevant international convention. That's Cuba, its signal. Cuba, after the rest of the world, have a lot of problems. The problems are related with environment, and here you can see the more important of this. But in my opinion, the most important thing or the more important problem that we have today is related with the generation of electricity. Because today we use as the first one source, the traditional source. The 95% of electric came from non-renewable source. Oil and natural gas are the 80%, and only the 4.9% are renewable source. In Cuba, as well as in international fields, research of climate change began to be carried out in the 90s under the responsibility of the National Academy of Science. The first studies of climate change, in fact, were made in 1992 and continue until now. In 2004, the country was hybrid to strong Europeans, and the strategic decisions were adopted by the state, and it maintains until today. Since 2014, every year, the most recent scientific information has been improved to the government, especially in rising sea levels. In November of 2066, our former president requests that the scientific information be transferred to a police platform with enforceable measures to solve or reduce climate-related problems. After that, the first state plan was approved, and its name is Lea di Salvatore. As an island, the climate change effects are more intensive in Cuba than in other countries. The climate is warmer and the weather is more extreme. The variation of temperature during the day has moved several degrees. To date, in Cuba, the country's climate is undergone a complete transition for a humid tropical climate toward a subhumid climate, in which the permanence of rains and the quality of water, soil conditions, and temperature will be different. The level of the sea is also increased. In Cuba, the most common natural disasters are associated by tropical cyclones that affected the country between June and November. Associated with the tropical cyclones is happening the phenomenon of known as outweighing, that is the rise in the sea level caused by wind, leading to the coastal plummets. Since 1996, we have a very active cyclone space with hurricanes category 3, 4, and 5, relative increase in drought and intense rainfall in the dry period. Today, the rise in the sea level has effects in our coast. The future projections show the increased level of the next 100 years, confirming that the risk, which would imply the slow decrease of the emerging surface in the country and the gradual salinization of underground rivers. The impact will increase and we will lose coast land. In Cuba, a lot of people live near to the coast, and they're highly vulnerable. A lot of them could be lost their permanent housings, and others could be displaced. we are working in moving the coastal community, but it's not so easy because moving implies change in their way of life, cultures, and traditions. This whole process to relocating people who reside in the high risk is financed by the state. New communities has been built, but we need to rebuild and stating where people have a social service and their way of life. And this is more complex when the community work is likened to the postal as efficient. That is why the relocating community is considered an extreme measure to be applied only when all the measure has been exhausted. When you live in a long and narrow island, you can not solve problems in the coastal areas through relocating the population. So it must be resolved with measures on the coast using the national solutions whenever it's possible. Here you can see some numbers of the principal, the main effects that we have in case of the coastal community. As I mentioned before, from confronting climate change, we have an estate plan, life task. It's a plan of action carried out by the state administrations and institutions for adaptation and mitigation of climate change. In line with the country needs and in compliance with our international conventions. It is coordinated by the Ministry of Science, Technology and Environment. Life Ties is a policy response to the Cuban scientific information on climate change. All Cuban state institutions must respond with a plan of action in the short, medium, long term, and very long term, because environment change are not perceived within 1 or 2 years. So we have 4 or 5 years as a period to evaluate the effects of climate change in our country. This action involves all sectors of Cuban society. One of the main actors of the communities are the people who development economically, socially, and politically through them. This task or this plan have 5 strategic areas and 11 tasks. Each one involves not only scientific institutions, but also administrative, research, educational, and cultural. In fact, every sector of Cuban society is involved in this action. The plan promotes undertaking action and projects for adaptation and mitigation to climate change in 60 areas identified as most vulnerable. Its objectives include conserve and fully recover the beaches, ensure an use of the water, directed reforestation, maximum protection of soils, rehabilitate the coral areas, and the implementation, control, and evaluation of the adaptation and mitigation measures. In 2019, a milestone in Cuba's constitutional history took place with the approval of a new constitution. The new text shows a credited leap with respect to the former constitution that was adopted in 1976. Due to the change in the structure of the state, the economic sphere, citizenships, rights, the guarantee of the rights, and the electoral system. The Cuban constitutions adopted in 2019 contains a directive provision of climate change and the environment. It's the first Cuban constitution to mention the topic of climate directive, in this case, as a part of the Cuban international relations principles. The former constitution, as I told you, was approved in 1976, and in those years, there were still not studies on climate change, and it had not yet identified as environmental problem for the world. In 1992, which made our constitution was modified, But this modification only include the principle of the sustainable development, no any kind of expression of climate change. Now, in our constitutions, you can find in the Article 16F a phasing to the climate change, a principle of our foreign policy, with other international principles, the shares and different responsibilities of the states and the search of a new world economic order. This provision is related to other articles, specifically Article 8 that establishes that the international treaties that are enforced in Cuba form part of our integrated national judicial system. And as you can see, Cuba has been signing a lot of international instruments in these fields. The new texts recognize for the first time the right to enjoy a healthy and balanced environment and maintain the duty of the state in the protection of the environment and the national resource, as well as the inclusion of the principle of sustainable development in the Article 75. And in the Article 19, you can find the duty of the citizen to wise for the preservation and healthy environment. After the entry in force of the new constitution in 2019, a legislative plan for the implementation of the constitutional provision was approved, established that a new environmental law should be presented by 2022. The Ministry of Science, Technology and Environment was in charge of preparing and submitting the new environmental regulation to the National Assembly. It took place the last year, and in May of 2022, the new environment law was approved. It was denominated Natural Resource System and Environment Law, but it hasn't been yet published, and therefore it has not entered into force. In the new law, you can saw there is 5 parts. There is 2 parts. The dispositive part have 6 titles, and as you can see, in the case of the title 5 is related about confronting climate change. The second title is very important in this case because that is the reason for we changed the name of our environmental law, because in Cuba the natural resources are related and it be administered with the different ministries, and that is why in our new environmental law we established that the Ministry of Technology, Science and Environment have the responsibility to control all natural resources. And this new law, the new law is more comprehensive standard than the previous law. The dispositive part, as you see, include 2 new titles, environment quality and the confronting climate change. The new environmental regulation has a group of complementary laws, including a decree law of climate change, which has not been yet approved, but have already been a draft. The subjective project of climate change is focused on development from the regulatory point of view, taking account the commitment assumed of our country with the Paris Agreement. This regulation is purposed to be carried out on the principle that confronting climate change is on a public interest and social utility. That is why the first part of the new decree law is for establishing the function of each human ministry and other organizations of the government and community. It will also encourage the active participation of all actors in society and is intended to regulate the general basis for adaptation and mitigation actions. In case of mitigation, it is planned to include a different action, such as replacing the use of fossil fuels, renewable energy sources, promoting technologies whose emissions are low, and promoting reforestation and sustainable use of the forest. Adaptation actions include the determination of land use based on its national location, the establishment or relocation of populations in communities in the coastal zone, especially the management, protection, conservation, rehabilitation of the ecosystem in this area, forest resource and zones, and the conservation, maintenance, and rehabilitation of the beach. Finally, the new decree law also includes a chapter referring to the financial and investment management and planning. All of them are necessary to implement the mitigation and adaptation action together with economic impact. Cuba have a lot of work to do, a lot of work to make, but our government approved another important law after the promulgation of the new constitution. In this case, we have, for example, an agricultural regulation, soils regulation, security food regulations, and all of them have an important dimension for concerning the climate change. In the case of energy, we have a legal framework that was to promote the use of renewable energy, but unfortunately, we don't have enough technology and a good financial situation to comply our commitment. In the last year, our government increased the commitment to the use of renewable source to the 27%. We have a lot of challenges, but we are working to confront the climate change. Thank you very much. Now, if you want to make me some questions, I'm here for you.
Thank you so much, Professor. At the risk of ensuring that we have some time to answer questions, I'll just provide a brief summary of what our previous presenters had spoken about. We had the first presenter was Professor Heffron, who presented on just transition litigation, a minimum performance standard. We then heard from Professor Renata Piesner-Ebner on energy efficiency first, considerations on energy saving and law. We then had a presentation from Dr. Monika Feigerlova, who presented on climate corporate due diligence. Our next presenter was Lea di Salvatore, who discussed the role of international investment law in protecting fossil fuel investments. And our last presentation was from Professor Toledano Cordero, who presented on transitions in the South, climate law from a Cuban perspective. I would now like to open the floor to any questions. I believe that there is a question in the chat already. It is from Eric. It says, a question for Lea di Salvatore. Under what conditions is it possible to compensate global energy corporations when they claim that the climate measures adopted by governments affect the expectations of future profits? For example, indirect expropriation free trade agreements. While on the other hand, it is considered that it is not possible to estimate the damages to future generations, since it is argued that they do not exist. Isn't this cynical gaze the one that is at the base of the planetary devastation and the global climate crisis? Over to you, Lea.
I didn't catch the name, Eric, right? Yeah, yeah. Thank you very much. So you pose a very interesting question because there is an incredible imbalance in between the amount of money. I'll start with this because your question has different layers, but I'll start with this. There's an incredible imbalance in between and the amount of money that is awarded to these corporations as we saw, billions of US dollars, and the amount that is awarded to claimants in climate litigation cases, for example, in human rights courts. Like we're talking about a few millions compared to the few billions here. Because if you look at the case, for example, the European Court of Human Rights and other human rights and other cases, the sum is ridiculously lower than the one granted by investment tribunals. So one of given, besides this consideration, I'm not too sure what you mean with under what constitution is possible to compensate global energy corporations. I mean, they are compensated usually by international investment tribunal when the measure amounts to direct or indirect expropriation, or for example, when there's been a treatment, let's say when a measure is claimed to treat them differently. And that has happened also. I will give you a quick example of how they have used treatment measures. So a fair and equitable treatment and most favored nation treatment. In one case, they the claimant, so the host countries put a tax on importing fossil fuels, and on exporting fossil fuels, and that was to the entire industry, regardless of whether they were foreigners or whether they were local nationals, and so the tribunal interpreted as to be unfair to these investors, even though it didn't. It was the same treatment for national and foreigners. The treaty found breach of treatment provisions because it was unfair to this specific sector. So there are many instances in which fossil fuel investors are awarded compensation. The worst of them all is the legitimate expectation, because it's how much money they were expecting to make given that specific circumstances when they concluded the contract. So I don't know if that is exactly what you were asking, but yes, future expectation future profit are usually claimed under legitimate expectation. And it's very interesting because you were talking about you hint at the future generations, while here it's just about profits. It has nothing to do with environment, or these treaties are only and uniquely there to protect the profit. So they're expecting, so whatever they thought they were going to gain in profit from these investments, the country has to pay them, in their view, in the view of the system, has to pay it back for the lost profit in the future. And I will tell you more, the way they calculate these, often with discounted cash flow, has been considered by some, like Papadisky, as crippling compensation, because they calculate these incredible amounts. And bear in mind that arbitrators usually do not understand the maths behind it. They are experts that calculate these amounts, and they say you were supposed in projects. So when it becomes extravagant is when projects haven't started yet. You haven't seen a profit yet. The thing has not started. So there has been, for example, the exploration, but the extraction has not started. Okay. So based on how much they thought they would be extracting, they're claiming this. And the tribunal calculates through discounted cash flow how much they would have been, how much they would have profited from this investment. The thing is that there has been no line of profit yet. So how are they even supposed to estimate the future profits? And this is also ridiculous to apply to the oil and gas industry that fluctuates, where the price fluctuates so much. So I'm sorry for taking so long in answering the question. I think that covers it. Thank you very much.
Thank you, Eric, for the question, and thank you, Lea, for your detailed response to that. Once again, we would like to remind everyone that if you have any burning questions, please do feel free to post them in the chat or to raise your hand. Renata, over to you. I see you have a question.
Yes, a question and a remark maybe to Lea di Salvatore. It's very interesting you presented the enterprise and the project and how the amount they contribute to the climate pollution, the pollution of the atmosphere. So I consider maybe you said this transparency is very important topic in that context. So there should be considered maybe a kind of a transparency obligation where the enterprises have to make transparent their projects and how they contribute to climate pollution, the pollution of the climate, of the atmosphere, and but maybe it should be connected to another thing, that not only this project should be, and that should be a transparency obligation for that. It should be a transparency for obligation also for the renewable energy project they had, and they should maybe they can also make transparent how this project make a positive contribution to climate protection. So that can be considered maybe. And so can you tell us how is there a kind of provision in that context planned, or is it quite a new idea, and when it should be determined, where on which place should it be determined? That's the one thing. And the other thing I wanted to I want to make a remark to Dr. Monika Feigerlova. Very interesting presentation, and the Article 25 from the directive you mentioned, the duty of care from the directors. That's really very interesting aspect, and they have to, because you told us they have to take into account the consequences of climate change in their decisions. That would be an amazing step if that would be adopted by the Council. So my first question is, how are the how big is the chance that that really comes? And the other thing is, yes, do you mention the sanctions, and how should these sanctions be constructed? Does the firm, the enterprise has to pay, or the natural person, or you can tell us something about that? Thank you.
So first I'll hand over to you, Lea, for you to answer that question, and then we can move over to Monika.
Yeah, thank you, Larissa, and thank you, Renat. So I'll be very brief. The answer is no. If we're expecting anything happening on transparency at the moment, it's not really happening. So there are several reform processes that are happening, that are currently undergoing at UNCITRAL, for example, or at the OECD. There are bilateral reform processes where they're remodeling bilateral investment treaties. But the reality is that although transparency is one of the top priorities, they are not at the moment. It's very much blocked. It's very much stopped. So it would be unspeakable in the future to have awards published, claims published, especially when we're talking about natural resources and public interest. It's very hard to even conceive that these are not public, because this is in the interest of the citizens, and it's there also, it's tax money. So yes, it's an aspect that needs to come out, but at the moment we don't have. Just the fact that ICSID publishes that there is a case, it's already something great to give an idea of the challenge at hand here. and the people in favor of the system are extremely against it. So there is a very important pushback from the sustainer of this system.
Thank you, Lea. Over to you, Monika.
Thank you very much, and thank you very much for the questions. Yes, that's as regards the director's duties, it's yes and no improvement, in a way that under some national laws it says that it's said that actually the duty of directors actually encompasses also other non-financial interests. But you are right that if it is in writing and expressly said that actually this is at the same level as financial consideration, it's a huge step forward. The backlash is that there was no agreement about, and that's why in the provision there is the reference to that actually national, it's up to national legislations how they will derive the consequences of it. So there is no like harmonized agreement what would be the breaches. And as regards the sanction mechanism, the administrative sanctions, for example, for not adopting the climate transition plan, I think monetary or pecuniary sanctions are probably quite likely that would be the measure. But the question is what the administrative authority can actually check whether it's just the climate transition plan was or was not adopted, or whatever. Actually it could look into the content and say, well, it does not actually meet parameters of any climate transition plan. But also the proposal of the Commission says that the authority should be also mandated to order the cessation of infringements. So probably means that would invite the company to adopt the plan in a given time frame, or it can also adopt interim measures. So I hope this answers the question.
Thank you, Monika, for that. Carlotta, I'll hand over to you for your questions or comments.
Thanks. Yeah, thank you again to all the presenters. I'm very, very intellectually stimulated in this moment. I have a question for Professor Feigerlova. It is about the 1.5 target that you were mentioning in the European directive. So I know that this has been an argument also in climate change cases against states that they should comply with the 1.5, but I don't understand how you can ask a single actor to comply with a collective goal without distributing the effort. And I think this might be even more challenging when it comes to companies than when it comes to states. So how do we translate this target into a meaningful target for a company? If you think that that more indicators should be added to this directive to understand really their obligation, the state obligation as an obligation of conduct, as a more specific obligation of conduct, because I don't see how it can be an obligation of result in the context of climate change. And I don't know if there will be enough time for answering the questions, but I'll just throw them. And if this reporting directive can be can be an interesting instrument for greenwashing claims when companies are not reporting their emissions. And yeah, I must say, with regard to the topic of Lea and that Matteo, Professor Feigerlova discussed yesterday, I can't get my head around certain things because I also know very little still about it. So, for example, I don't understand how an arbiter can interpret international investment law as a completely specific piece of legislation independently from other sources of law. And is there a way, this is maybe an innocent question, is there a way to hold the arbiter accountable? So I understand that the law is very biased towards protecting economic interests, but I also understand that there is a responsibility of the interpreter here, interpreting the law very much in that sense. So do you think there are ways to hold the arbiter accountable in cases where its interpretation of the law is very much against other sources of the law. And here I think also about possibly using European Union law sources, if not at the international level, at least at the national level, as a possible way to push a change in this law.
Yeah, so if I may answer the question, which I totally agree, I think it's a more symbolic value, the 1.5 degrees Celsius, or when the Commission made the proposal, it's just somehow transform what was in Paris Agreement. But in, as you rightly point, in the climate change litigation, many national courts are actually facing the challenges how to or maybe are inventing methods of calculating carbon budgets. So it's even in the legislations which should be legally binding and under sanctions, I believe that it's not the benchmark. So and I think correctly the European Parliament added the climate neutrality. So maybe if we think about a business model that of a company that is should achieve climate neutrality by 2050, then it's more comprehensive in my view, and also can allow setting different targets how to get there. And then obviously there will be, I think, further rules how a company can use offsets. So I don't think so that the 1.5 degree could be challenged or will be the basis of any actions. That it will really depend on the other details of the climate transition plan. And as you point correctly, also it could be opening door for greenwashing. And this is here I see the danger if this document is not aligned with the Corporate Sustainability Directive, because you actually watered down even what was agreed in other document, which is kind of the result of the process that you should achieve. And here you don't, you kind of take a more flexible and vague approach on the companies.
Thank you once again to Carlotta for the question, and thank you, Monika, for your response. Before we move into our PhD session and the presentations of our PhD candidates, we think that it is suitable for us to have a 10-minute break now so that everybody can grab a coffee and stretch their legs. Before we do that, I'd like to take an opportunity to thank our presenters once again for really insightful presentations and for providing us perspectives on not only the just transition as its concept stands, but in relation to investment law, to corporate due diligence, to considering just transitions within the Cuban perspective, also looking back at energy efficiency with this as the concept and the principle as it stands. Once again, we are appreciative for those of you that have joined us for the first half of the session, and we hope to see you again for the remainder of the day as we move into our PhD candidate presentations. Thank you, and we'll see you after the break.
Thank you.
Thank you.
Hello, everyone, and welcome back. I hope you have all had a chance to stretch your legs and enjoy a short break. We will now be moving on to the second half of our day, which consists of the doctoral candidate presentations. We have 3 presentations today. The first 2 will be done online via Zoom, and our last presentation is from a PhD candidate that is currently in Cuba. So we will be listening to a video presentation and then contacting him for any comments via the phone. So I would now like to hand over to our first presenter for the doctoral candidate presentations, and that's Jesus Ramon Jimenez. He's currently at the University of Zaragoza in Spain and is also affiliated with the Latin American Faculty of Social Sciences in Ecuador. He will be presenting on a green central bank digital currency, so a green CBDC. Jesus, are you with us? Hi.
Hi, hello. How are you?
I'm very well. How are you?
I'm fine, thank you.
Thank you for joining us. I think you should be able to share your screen. I'm not too sure if you have tried it as yet.
Okay. Can you see the screen now?
Yes, I can.
Okay.
Perfect.
Well, it's going to start. My presentation is about a green central bank digital currency. She already said my name. I am Jesus Ramon Jaime Becerra. I am a PhD candidate from the University of Zaragoza in Spain. I'm doing right now my PhD stays in Flaxo, the Latin American Faculty of Social Science in Ecuador. And originally, I'm from Venezuela. So let's go to start from the beginning. I assume that everybody knows what is a central bank digital currency, but I would like to explain for those that don't have any idea about this. And this is very interesting because this is an economic issue, and I taking this subject and making it also environmental. So what is a central bank digital currency? Well, this is a digital currency that, as its name indicates, is issued by a central bank. And with a difference with other digital currencies such as Bitcoin or Ethereum that everybody knows that is in the news all the time, this is not necessarily backed in cryptography. It can be backed in what the central bank or the government, if there is no central bank, indicates. For example, there is a case in Venezuela about a currency, a digital currency that the name is Petro, that is backed in the price of oil, not their amount, but their price. So it's very interesting to back this digital currency in a natural resource as oil. So now that we know what is a central bank digital currency that can be backed in whatever that the government indicates, let's go into the following. So what is the state of the art about CBDCs? What is happening right now? So right now there is at least 5 CBDCs in operation. We have the Bahamas dollar, that was the first one. The RMB from China, that is one of the more powerful because of the size of China and the economy of China. The Yandex from Jamaica, the Dcash from the Eastern Caribbean Central Bank, that is a group of islands, the group of central bank of the Caribbean island countries, and the e-Naira from Nigeria, that is implemented in all the countries. It's the first country that we have a CBDC working in all the country. So since this month, since May of 2023, in the city of Changshu in China, the salaries of public workers has been paid in the CBDC of China, the RMB. So this city has an estimated population of 1.7 million people. So China is testing right now their CBDC in approximately 1% of their population. So they are going to have a lot of data fixed on everyone. So right now, more than 100 countries are interested in their own CBDCs. So we are going to have digital currency very soon, everywhere. Even in Europe, they have the digital euro right now. So let's go into the title of the conference. What is a green CBDC? Well, everybody can think that a CBDC is something that the government issue, a digital currency that the government issue, taking the environment into consideration. But in this research, I'm going to show you how a CBDC can be issued according to the total of the green energy production of a country. So imagine this. We need more green energy. Everybody needs green energy. And also the economy needs to grow all the time. So what will happen if we link these two issues? If we mix the green energy production to the size of the economy of a country? How can we do this? How this can be done? So I propose this simple formula. I'm no mathematician, I'm a lawyer. So this is very simple. We take $1 million is equal to the amount of gigawatts per hour in a given year. This is the regular way that they measure, that the engineers measure the amount of energy is gigawatts per hour in a given year. And we divide it, can be between 1 or can be between any other number. So this number, this one, you are going to see that can be altered. Okay. So what I'm trying to say here is that for every gigawatt, there is a great amount of electricity produced with green energy. The central banks are going to have $1 million. So we can say, well, this is interesting. Let's going to see how this works. And this has other benefits, apart from the obvious, apart from link these two things, apart from link the economic and also the green energy. This will offer a standard for CBDCs all around the world. Everybody is going to, every country is trying to create these CBDCs, but they're saying, okay, how can we limit these CBDCs? So this is something that will offer a standard, can be easily verified, because everybody can verify how much electricity can produce a country. There is even apps for that. So let's go into the next point that we already mentioned, the standardization and fairness of the use of CBDCs. As already mentioned, there is a need for standardization for these CBDCs, for the interoperability, that everything is produced in the same way. But this is the advantage that CBDCs don't have against Bitcoin, because if anybody produces a Bitcoin in any country, can be Venezuela, can be France, can be Nigeria, this Bitcoin is going to have the same price. It doesn't happen the same with currency around the world. Everybody knows that we have the price of the dollar, and this is not the same price than the euro. It's not the same price that the British pound. It's not the same price that the e-renminbi, for example, and e-renminbi against the dollar is 1.7. You see? And if we produce a CBDCs, they're going to have different price. So with this system, no matter which country produce this green CBDC, is going to have the same value. So this is very, very good for convince people production. And also, when we talk about economies, we have to think about the standards in economics. We cannot create a rule in economics. We cannot change all the money around the world. So we have to take a standard that will be already accepted worldwide. So there is something called the total reserves or central banks. This is the monetary gold, the special drawing rights, the reserves of money that have these countries. That, for example, the currencies more spread are the dollar, the euro, the British pound, the yen from Japan, the yuan, and the yen from China. No, the yuan from China and the yen from Japan. So how work this correlation that I'm telling you? Why this is the thing that why this research is important? Because we need numbers. When we are going to talk about something like create a digital currency, we need numbers. We need to compare with something that is already established, that is something real. So let's go into analyze the total green energy production of China. So we have this number. And if we compare, just comparing numbers, with the amount of total reserves is almost the double, and we can find almost the same number. There is almost a correlation. And the correlation is 1:2. So it's the 54%. Okay, if we convert all the green energy of China, and we start to say, okay, this is the total resource of China, they can back the 54% of their total reserves. We can say, okay, 54% is not that much. Okay, but what happened with this? The percentage of total green energy produced by China is 25%. So let's imagine for a moment that more countries decide to adopt this currency, not just China. For example, we have Brazil in Latin America. We cannot say about the United States because the United States, as everybody knows, has the Federal Reserves and they create money as they want. So their total reserves are very low compared with the green amount of green energy that they have. So we cannot have this right now with United States. But with other countries that they already have total reserves, for example, Brazil, we can find the same correlation, almost the same that we can see in China. It's almost the double when we compare the total amount of green energy production, we come back of their total reserves. Canada don't have reserves, the same thing that the United States. But we can see also with China, they will be able to back 20%. With Russia, 17%. No, yes, 17%. With Norway, 98%. With Germany, 30%. With Japan, 12%. That is the same thing, it's exactly the same thing that the total amount of green energy production. With France, 28%. So as we can see, there is a correlation of 1:2. So we can change the formula. We can adapt to be between 2, and they are going to be exactly the same. They're going to be 50%. They're going to be 150. They're going to be more close. So this is just for these countries that I just mentioned. This is just for China, for Brazil, No, this correlation, we made a research, and it can be found in China, Brazil, Russia, Norway, France, Italy, Turkey, Sweden, United Kingdom, Colombia, Argentina, New Zealand, Indonesia, Chile, Australia, Portugal, Romania, South Korea, and Iran until now. We have just analyzed 40 of the biggest producers of renewable energy. So this accident, because it's not planned, it's just a coincidence, can be used for change, not all the economy, but almost all the economy, because with this green CBDC, if we stimulate the creation of money, we attach the creation of money to the creation of green energy, we can assume very easily that governments are going to start to invest in green energy in order to create more money, in order to have more money. Of course, everything is limited to the natural limitations that everything have, the natural resources have. So why do we need that much money? What do we need in order to stop climate change? Well, according to the United Nations, we will require an investment of approximately 22.5 trillions of new renewable energy installed. Where we are going to get all this money? Well, this is the solution. This is the solution for get all this money. It will be just for everybody, because it will be according to the amount of green energy that they are able to produce. What are the benefits of this proposal? It would standardize and secure all the global financial system, because it will be predictable. Everybody can measure the amount of green energy. Will be a common platform for all central banks for their reserves. The use of renewable energy to issue digital currencies can help to raise the awareness to banks. They're going to say, okay, we need to produce green energy in order to have more money. And it will be access to everybody to a decentralized currency that is not going to depend on one country, but everybody will be able to have it. It will be a real international currency. So what is the limitations to the application of a green CBDC? Well, this is the problem. Monetary policies answer to the economic and political needs of countries. So this creating of a new standard cannot work for the entire monetary masses, because we need that the countries have freedom. We cannot create a big communism or a big socialism or something like that. So this has to be limited just to the international reserves of countries. So this will allow to countries to have flexibility in case of crisis or in order that they need more money. But we have to consider it will facilitate the $1 trillion of investment to avoid climate change that we need right now. So the conclusions: a green CBDC system will facilitate the accomplishment of the Paris Agreement by directing the finance flow to a climate resilient development, and at the same time will stimulate the CO2 decreasing. So this is not a solution. Nothing is a solution, but this is an alternative that it will be worth further studies. Well, thank you very much. This is my contact information. If you want to discuss your research or you want to discuss about a green CBDC, and I'm open to questions.
Thank you so much, Jesus, and thank you for providing us an insight onto knowledge relating to this new kind of digital currency. I think ever since, like you said in your presentation, the establishment of Bitcoin and Ethereum, the discussion on digital currency has become more and more prominent. So it's really interesting to see your take on green digital currency and the utilization thereof. We'll now move on to our second speaker, Ms. Sheila Val Rodriguez. Sheila is joining us from the University of Graz at the moment. She is at the University of Graz on an exchange with our partner university, the University of Havana in Cuba. She will be presenting on tax law and climate change. Sheila, are you with us?
Yes, thank you very much, Larissa. Good morning, good afternoon, good evening to everyone. Please, if you can show the slides. Now I will begin my presentation. As just Larissa mentioned, it's about taxation and renewable energy. Renewable energies have arisen as a way to fight climate change, and because they need huge investments, we thought about using tax mechanisms to promote the use of renewable energy sources to get electricity or the energy for transportation. Right now, the approach is general, so we can go at a certain point, can go further, but this is what I'm going to present now. Please, next, Larissa. So the summary we are be discussing is going to be the national background, Cuban tax system, then tax incentives for renewable energies, and also the scientific problem, hypothesis, the methods and techniques I'm following in my research. Continue. To begin with the national background, we will have to say that in the case of Cuba, this is a vital issue because almost our entirely energy matrix is based on fossil fuels, and this translates into a high dependence on imports of hydrocarbons and their derivatives, and the existence of a sensitive situation with respect to the balance of payment to maintain a constant supply of crude oil, not to mention the dire consequences that may result from maintaining a non-renewable energy matrix. It's the fact, the essential fact that led us to think that we need to do the transition. So we have on one hand, all the environmental issues, and on the other hand, we have the economic issues related to support that energy matrix. Then, as Professor Toledano previously stated, we have a constitutional mandate of the state to protect the environment. Specifically, Article 75 provides the right to enjoy a healthy and balanced environment. So the state is obliged to present mechanisms to guarantee the enjoyment of this right. And also, this article emphasizes the protection and conservation of the environment and the confrontation of climate change, which is the pillar to develop then the public policies. Next. So when talking about our public policies, we can mention concrete actions, and we've been improving them since 1959. We can talk about researching groups, installation of photovoltaic systems in rural areas lacking electricity. And in more recent years, we can talk about a few documents They are the guidelines of the economic and social policy of the party and the revolution, the conceptualization of the Cuban economic and social model of socialist development, and the National Plan for Economic and Social Development until 2030. All of them have highlighted the need to promote, as part of the energy policy, the generation of electricity from renewable energy sources, especially sugarcane bagasse and sugarcane forestry agricultural residues. We can also mention the use of biogas, solar, wind, hydraulic, and biomass energy, giving priority to those with the greatest economic impact. Also, these documents have discussed the country's potentialities regarding to the use of renewable energy sources. That's why it's essential that the states continues with the establishment of the policies which promote them, so we can increase their participation in the energy matrix. Again, as Professor Toledano previously mentioned, we want to increase that matrix up to 27%. Right now, doing the math is around 5%. So going from 5 to 27 in a period of 7 years, because that goal is for 2030, is an ambitious plan. And then we need all the public policies we can count on, we need the investments, and we need a legal framework that will be adequate for promoting the use of renewable energies. That's why electro-energy sector has become an strategic sector, and we have developed an important legal framework. Please, Larissa, continue. Yes. This framework consists basically in 1 decree act, 1 instruction, and 11 resolutions. 3 of them are regarding to tax incentives. And I mention this because, well, as the research is about taxation, then we can see how it is reflecting one of the mechanisms to get the investment in our legal framework. What happens with the Decree Act, it is that its objective is to be the foundation for the development of renewable sources and the efficient use of energy. This norm establishes a definition of renewable energy sources, and it also establishes an order of priority that responds to national interests, highlighting the role that sugarcane biomass is called upon to play as the main renewable source of energy, although not the only one. And it also provides a general regulation of tax incentives. And these tax incentives are then the ones developed in these 3 resolutions. Now, before going to analyze the tax incentives, we should talk about Cuban tax system, which is the base to establish tax mechanisms. So when talking about Cuban tax system, we need to first know that given that exploration of renewable energy sources needs huge investment, this is the point where the administrative activity of promotion arises. And when referring to the activity of encouragement or promotion, the administration has a variety of mechanisms, such as subsidies and tax benefits. We are focusing on tax benefits. And then in the case of Cuban tax system, taxes are defined as an obligation to pay a monetary sum whose purpose is to obtain the necessary resources to meet public spending and other matters of general interest. These concepts, well, it puts on evidence the coercive and pecuniary nature of taxes and is based in the principles of generality, equity, and economic capacity, or as it is also called, ability to pay. And in here, the most important pillar is the fact that taxes can be used for other objectives than receiving money, collecting money to the public expenditure. So that's why we're talking about instrumentality of taxes. And then we are going to use that instrumentality to promote certain type of conducts. It will be through administrative sanctions, but in this way they will be positive instead of negative. We are going to influence people's behavior in order to get them to produce renewable energy, through renewable energy sources. Going forward to the tax incentives regulated in our country, please, Larissa, we have a tax incentive for tax on profits. This consists in a total exemption for a period of time, which is 8 years. This period of time starts the countdown once the company has started the commercial activities. Of course, this is for companies who are producing electricity through renewable energy sources. It's not for any kind of company. And once the 8 years period, have finished, then we have a reduction of the tax rate. When analyzing the regulation of tax on profits in the Cuban tax law, the general tax rate is at 35%. And for these incentives, it decreases in a 15%, so it will go for a 20%. However, which is the more interesting part in this incentive, is the fact that we have a few actors in Cuba's economy. Just to mention, we have joint ventures, cooperative, limited companies, public companies, and we have also in the field of foreign investment, stock share companies with totally foreign capital. And these are the only ones that will enjoy this benefit. So we potentially have other actors that could produce energy through renewable energy sources. And then there is a unique actor who is going to be the one enjoying this benefit. Of course, there is a logic behind that, which is as we need huge investments for the renewable energy production, then it's quite obvious, quite correct, yes, quite correct that we prioritize the companies that are a product of foreign capital, that are related to foreign investment, but we also have joint ventures, and they are also a product from foreign investment, and they are not enjoying this particular tax benefit. Going on, we also have some tax benefits in the custom duties regulation. Please, Larissa, continue. And in here, I'm talking about 2 tax incentives because I'm differentiating the subjects and also the object of the incentives, it's quite different. Similar in some aspects, but quite different. And that's why we can talk about the same companies having a total exemption for the importation of machinery, equipment, and other means necessary during the investment process. And we have this other tax exemption, which is really interesting because it's also total, but it's for individuals. And the idea behind this tax exemption is to promote the self-generation of electricity. That's why to enjoy this tax benefit, we need that the importation won't have a commercial character. And then we have quoted, which are the machineries and equipment that can be imported by people. These, as I was mentioning before, it's a good idea to get people involved in the production of electricity for them to consume. But these tax incentives, if you want to promote the production of energy through renewable energy sources, they are not enough. And that's why, go on, Larissa, next. We can conclude that from this, that okay, there are tax mechanisms for promoting renewable energy and they are based on taxation principles, but they are subjective exemptions. They are not focused on the field, but yes, they take into account the field, but they are focused more on the subjects than the field and the end we want to promote. But at the same time, there is a rising interest in the use of renewable energy, and that's why we are calling to regulate a special taxation regime for renewable energies. From this point, next, we establish as a scientific problem what should be the theoretical legal foundations for the design and application of a special taxation regime on renewable energies in Cuba. What is here to take into account, and it's the hypothesis, are the basis for the special taxation regime, please. And we are talking about primarily three aspects that we need to take into account. And the first of them is the non-fiscal purpose of taxation, its instrumentality. As we were previously discussing, we can use taxes for promoting some type of conduct. We can stimulate a conduct, we can destimulate a conduct. We want to stimulate the production of renewable energy, the production of energy, sorry, using renewable energy sources. Then there is an important aspect that should be taken into account, which is that the special taxation regime, when establishing the incentives or itself, we should look at the efficiency in direct production instead of the installed capacity. And why? Because tax incentives, a different treatment, should be in function of the units of renewable energy generated, which rewards efficiency in direct production. In the case of investment incentives, tax credits make it possible to directly reduce, partially or totally, the amount invested in renewable energy from the taxes to be paid, which could limit the scope of the incentive or the special taxation regime to the installation of machinery and not to the generation of energy itself. And that's because a subsidy is produced for the investment made and not for the efficiency of the operation. So this is important because installed capacity is not always a guarantee of success in operations, and when analyzing tax incentives, a different tax regime, we cannot forget that this type of measure have an indirect cost, since the state does not receive all the income that is expected for public expenditure. So there should be a balance, and the best way to get that balance is focusing on efficiency instead of installed capacity. If we go back to the tax incentive we have developed, they are more focused on installed capacity instead of efficiency in direct production. And the third aspect that I would like to mention to take into account when establishing the special taxation regime will be the structure of taxes. When configuring tax incentives or any kind of tax mechanisms, the legislature has a few categories to work with, such as the tax base, tax rates, tax liability. Also, we can talk about exemptions, favored tax system for a special area, which is the case we are analyzing, a special taxation regime. But we have different categories to work with, and we should analyze, given the case, would be which ones would be better to apply. For example, it could be doing deductions, decreasing the base rate by some accelerate mechanisms, or it could be a decrease in the tax rate, or a combination of them. There is not a fixed rule for that, and that's why we focus within the methods and techniques. Go on, Larissa, please. And first of all, doing a theoretical and legal analysis of the institutions we are working on, then comparing different legal regulations between a few countries to check, to see, to know how are these countries that we're going to select implementing tax mechanisms in order to promote the use of renewable energy sources. We are thinking that the countries that should be taken into account would be some country from America because of the geography, because of their proximity to Cuba. We should consider Spain, given the tight bonds between our countries. Austria as one of the pioneers in this field. It will be interesting to know the perspective from an African country, which is also a vision from the South, but from a different continent, and a vision from a country using the common law system would also enrich the work. To add to these methods, then the techniques are focused on reviewing bibliography, and interviewing functionaries and people who are related to work with tax mechanisms and renewable energies. And well, so far, these are some ideas about my research. So thank you for listening. I hope you have find it interested, and I'm here to answer any questions you have. I'm open to any suggestions that you can make me. Thank you.
Thanks so much, Sheila, and thank you for providing us an overview of the Cuban tax system as it relates to taxes for climate change and establishing tax law and its connections to climate change, broadly speaking. We now like to move on to our last presenter of the day. Our presenter is Ernesto Sardinas. He's joining us from Cuba, so unfortunately, Zoom is not able to be used in Cuba, so we will be watching a video that he has sent in. I do have Ernesto on the phone, and he is available to answer any questions if anybody would like. And so I will now move on to the video for us to watch.
Be better in our.
Apologies for that.
Hello, good afternoon, and well, let's begin with the topic of this presentation that will be about Cuban energy law and green energy transition. So we will be following a structure based on three main moments. First of all, we're going to talk about the context of the new energy sector, its most recent history, the last 30 years. And after that, we're going to talk a little about the current legislation on the field of the Cuban energy transition into renewable sources. And at the end, we're going to talk a little about the perspectives of this transition and what could be better in our regulations to make a better approach on the subject in our Cuban law. So if we step on the end of the 80s decade, we have an economy that was strongly dependent of the USSR subsidized, and especially on the importation of crude oil that came from the USSR and other socialist countries that made our energy system very dependent on that. Although that situation, and 18% of the electricity was generated through renewable sources, mostly coming from the sugar mills that could burn the residual elements from the sugar cane and generate electricity with that. But when the USSR collapsed in 1991, then came a huge economic crisis known as the special period. Cuba lost the 80% of its foreign commerce and the 30% of this GDP. There was no oil. There were 60 hours blackouts that became very common. Transport almost entirely collapsed. The sugar industry was also progressively dismantled, and that reduced that 18% of renewable generated energy to 18% to 3%. And in order to tackle this crisis, they were taking several measures. For example, they were starting to use the Cuban crude oil to generate electricity. It was a very sulfurous oil that was bad for refining, but during the crisis circumstances, it was used in the Cuban power plants, and there were projects like Energas that promoted the use of natural gas for generated electricity that was also a resource that was able to found in Cuba. And of course, there was a promotion of foreign investments on the energy sector that was essential to the promotion of this project, like the example that I previously put of Energas. And of course, there were campaigns to promote the energy saving, to reduce the consumption of electricity with ads on TV, with signs on the streets, trying to convince people to save energy, to turn on the lights and all of that. And during that time, that we are now in the end of the decade, and by that time, the economy had kind of a recovery that allowed the energetic crisis to recede. And there was also a new moment in the relations with Venezuela that allowed, with the new government of Hugo Chavez there, that allowed higher supplies of oil. And then Cuba met the 21st century with a very stable energetic situation. But in 2005, there was an important breakdown in one of the most important Cuban power plants, the Antonio Guterres, and that created a new energetic crisis. So there were new measures that were taken to solve that were known as the energetic revolution. The energetic revolution, first of all, and looking for energy savings, supposed a massive replacement of electronic devices like ovens, rice cookers, refrigerator, fans, air conditioner, lamps, in order to use devices that consume less electricity. And there was promoted a transition to an electricity-based cooking. There were constructed several small energy plants around the entire, scattered on the entire island, to create a distributed generation system that was able to work when when the power plants, the big power plants, was out of order. And there were also several installments of photovoltaic panels in the non-electrified areas of the country, mostly on the mountains. And after that, there was a process of economic reforms in Cuba after the 6th Congress of the Cuban Communist Party. And within that process, the goal of the energy transition to renewable sources was considered something that was very strategic. So in 2014, Cuba approved a policy that aimed to have 24, at that time was 24, then it was, after that it was raised to 30. Back then, a 24% share of renewable energy generations. And to reach that, it has been promoted the construction of solar parks, biopower plants, eolic parks, and there were imported several electric autos and buses. There was promotion of the use of electric vehicles, for example, hybrid buses in the public transport of Havana. And now, if we enter to the norms that were regulating this, first of all, we have to talk about the Act number 81, the Law for the Environment. This has an article, the article 125, that states the preference in the use of energy to the use of renewable energy sources and equipment, technologies, and technical organizational measures that stimulates the conservation and the efficient use of energy. There is also in the Foreign Investments Act, there is a special promotion of renewable sources of energy as preferred investments in our legislation. And the most important norm about this is the Decree Act number 345 for the development of renewable sources and the efficiency of energy. It sets requirements for the integration of renewable sources into the national electric system, gives facilities, credits, and tax exceptions for any investments related with renewable sources. It prioritizes the installation of bioelectric plants in the sugar industry. Remember, that was a very important area of that 18% that we had in the past 20th century, and we lost. The sugar, it prioritizes also eolic parks, photovoltaic panels, and solar heaters, and the usage of agricultural, industrial, and urban wastes to generate electricity. That it mandates also to the electric company to buy all the renewable electricity that is generated by independent producers, and the mandate is also to integrate it into the national electric system. It has some mandates and a specific office, the ONURE, the National Office for Rational Use of Energy, to control the energy efficiency of all legal persons in the country, and every legal person must create a 5-year program for the use of renewable sources and efficient use of energy. So every legal person must have a plan that to say what will they do to promote the energy transition within the field of activity in the next 5 years. There are also other norms of interest. For example, there are several resolutions of the Ministry of Energy and Mines and the Ministry for Finances and Prices that authorizes natural persons to import photovoltaic panels and its pieces as exceptions to the normal regulations of the normal regulations to import goods. It exempts from custom taxes to the imports of photovoltaic panels and its pieces, and authorizes, that's very important, authorizes natural and legal persons to sell photovoltaic electricity to the electric company, which will be paid in convertible currencies, and it also will be discounted from the electric tariff. So that is in general what has been created to promote the energy transition. That's not all, of course, but it's the most general for a presentation of only 10 minutes. So what's next? So we have some challenges. For example, our legislation in the electricity sector, general legislation in the electricity sector, and our legislation in oil and gas industry is too old. For example, or act for oil and gas is from the decade of 30s of the past century. It's very old, and this legislation of electricity and oil and gas requires an update that is actually programmed for the next 5 years. We shall have a new Electricity Act and a new Oil and Gas Act. It's also necessary to improve the regulation of the Decree 345, because it clearly promotes the renewable sources, but we don't have clear goals in the time and for subjects. So we mandate the legal persons, for example, to create a 5-year plan, but we don't say to them how much they have to generate renewable energy, and we don't say, and we just say that we want a 30% share of renewable electricity in the 2030 year, but we don't say what how much will we have in 2025, for example? We don't have that steps, and that will be, to have it will be better for better results of this program of energy transition. And well, those are the most important challenges. And in conclusion, we can say that the energy transition is very necessary for Cuba to end our dependency on oil and its role in recurring energetic crisis that Cuba faces. In fact, we are now in another energetic crisis, and well, we have this plan to reach a share of 30%, because originally it was 24%, but it was raised to 30%. And we have that goal for 2030 that implies significant improvements in the economy that we don't have right now. And well, that plan means a huge challenge to achieve during the actual economic crisis that Cuba faces. And of course, it's imperative to overcome those challenges that threat the accomplishment of this goal. So we have to find a way to overcome it and to achieve such a goal, because it's essential. It's essential for Cuba to change its energetic matters and end that huge dependence that we still have on oil generation, and especially on the imports of oil to make our power plants and the distributed energy system to work. So that will be all for now, and I will be open to any questions you will make. So thank you very much for hearing this presentation, and thank you for the organizers of the workshop for allowing me to participate, and I wish you all a very good day.
Thank you once again to all of our presenters who have presented in the PhD section of today's workshop. We would now like to open the floor to any questions or comments that anyone may have. I see a raised hand from Professor Piesner-Ebner. Renata, over to you.
Yes. Thank you, Risa, thank you, Sheila, for this very interesting presentation. You mentioned you will, in your research work, you will compare 6 different countries, and which countries do you want to compare? I think Austria is one of them, but why did you choose the other countries, and what are the criteria based on this comparative work? And the other thing is, did you already identify interesting tax law measures that promote renewable energy production on the basis on incentives? Did you already have some special measures that you can present here? This is the one thing. And the other thing is a question to Ernesto, if it is possible. I don't know. Larissa, can you? I cannot hear you.
I'm just checking if Ernesto is still here. Ernesto, are you with us?
Okay.
Hello, Ernesto? Can you hear me? Renata, maybe Sheila can ask her question first, and then I'll just check that Ernesto is here, and then you can ask him your question.
Yes.
Okay, well, thank you, Renat, for the question. Well, to begin with, I mentioned Austria, I mentioned Spain, given the bond between Cuba and Spain. From America, and for the previous research I've been conducting, I think the best examples would be Uruguay or Argentina. because they have established regulatory provisions that promote the generation of renewable energies and the production of machinery and equipment for them. In fact, in the case of Argentina, they have tax incentives for the production of energy using solar energy. So then you have to see that they are not treating the sources in general. They go exactly to the source they want to promote. And for us, for example, in the point we are, in the situation we are, it would be better to do a first approach to the issue in general, and then maybe we can continue to developing these mechanisms and go through the different renewable energy sources. As I mentioned before, we are prioritizing sugarcane bagasse, but we could also prioritize solar energy, wind energy, because we have the potentiality to do that. And that's something we already discussed in a previous presentation, but it's interesting to see how these countries have regulated the promotion of renewable energies. And the fourth and fifth country I was mentioned, when I continue to write and to do the research, well, I will definitely know for sure if they will get into the writing or if they won't. But I was thinking in an African country, I don't have a country right now in my mind. I have to do a previous research to see if any of them has developed a few mechanisms, if they are if any of them is in the same situation as we are. So that's something I should go deeper. And also regarding to a country from the common law system, I was thinking that maybe it could be Australia, but still need to go also deeper. Thought about Australia to have a different context, also a context from another continent. But for sure, the countries I mentioned before, I've seen in them a tide, an important tide, and somehow they are related to Cuba or related to the renewable energy field, and they are good to explore. I can mention, for example, in Austria, I've seen that there are incentives for self-consumption of energy, self-production, and then self-consumption of energy. I was previously mentioned the ones in Argentina and Uruguay. I have them in here. Yes, which is pretty much that. I don't know, would that satisfy your question, or do you want to know something else?
Oh, I think, thank you. I think that's good. It's, I'm satisfied with the answer. And yes, it's good to compare different, not only the countries near you, so USA or the Latin America countries, and also other continents. That's a good idea, because the legal systems are completely different, but there can be more very interesting incentive, interesting ideas and measures that come out. So yes, that's good. I think very good. Thank you. Okay.
Oh, thank you.
Larissa, should I ask the question to Ernesto? Is it possible or not? I
Yes.
can.
Ernesto is with us, so Renata, I think you can ask your question.
Okay. First of all, many greetings to Cuba. Hello, Ernesto. Ernesto, you mentioned the decree 345. It's a very important energy law in Cuba, and you mentioned that every legal person must have to establish an energy plan and to promote renewable energy. And my question is, I knew the law, but I didn't really find sanctions for misbehavior. So if the legal persons do not comply with the law, are there sanctions or what are there consequences? Can you explain a little bit this point?
Okay. There is an institution that is in charge of controlling such behavior, which is the UNEP, and mostly they work through inspections. So they come into the enterprises and then they kind of evaluate how the situation in the energy in general is there. That includes, of course, the subject of these plans for promoting the usage of renewable sources. And if they don't accomplish what is expected from them, they have a bad plan or they don't have a plan at all, the UNEP, first of all, will demand them to create a plan of measures to overcome this situation, and if the bad situation persists, they may face stronger consequences for the directives of such enterprises. There could be sanctions. They could, if the misbehaviors are severe, they may even lose their jobs. But that is not the most common. But yes, they do face consequences, and this is a way of doing things that is pretty common in general, in the way that inspections and controls are held over the directives and people who rules in legal persons. Were they able to hear my answer?
Renata, did you hear the answer?
Yes, I heard it. I mean, there are inspections, but are there some kind of fines or something like that for misbehavior? Or
Ernesto, Renata has asked if there are any monetary fines or something that is of monetary value that has to be paid. So she says that she understands that there are inspections, but are there also fines or some other versions of sanctions?
As I said before, the sanctions are mostly administrative sanctions, and if there is a monetary procedure for that, as far as I know, there isn't. It's a procedure more administrative. The sanctions are more related to the typical sanctions of the Cuban labor law, you know, a temporary suspension from your position and things like that. And if as I said before, if the misbehavior is severe, you can even get a salary reduction or even lost your position, be demoted or something like that. But that will be in cases of very grave misbehaviors, and depends on the circumstances of any infraction of what is established law. But if there are fines, that were created for that specific topic, I do not know. I do know that there are fines for exceeding the electricity consumption regulations, which due to the crisis are pretty strong right now. But for the plans to promote renewable energies, as far as I know, that doesn't exist.
Okay.
Thank you.
Thank you so much, Ernesto. I'd now like to open the floor again if there are any other questions. If anybody would like to ask our PhD candidates any questions or make any remarks. Also to the PhD candidates, you had previously stated that some of your challenges for your research is particularly funding. Would you like to provide a little bit of insight there, and we can see maybe how we can find a way around this? We know that especially, yes, Lea, I see your raised hand.
Hi, yes, sorry, I didn't mean to interrupt. It just took me a while to find the hand to raise. So I have a question for Jesus. I don't know if he's still with us, Jesus Jaimes. Thank you. Your presentation was very interesting, and you I don't know about how you calculated that formula that you put forward or anything. I can't argue on any of that, of course. I just had so from my understanding, but I'm not sure I got it completely right, because this was it's very new for me, this topic. I don't know much about it at all. From my understanding, this new currency, right, would be basically a way to create money. It's like speculation on environmental, on low carbon energy, right? Like, or something in this sense. Yeah. So I was wondering if this currency could be interesting besides besides this scope for example, when we're looking at solution to create international carbon markets. So for example, imagine in a hypothetical world in the future where countries that have contributed the least receives, like say, work more like cap and trade, so they receive X amount of credit, that X amount of licenses to pollute, let's say, similar to the European carbon market. But again, I'm not an expert. Do you think that could be interesting to have this type of currency to set an international carbon market to reward and make the polluter pays and reward who pollutes less?
Hi, thank you very much for the question. Well, what I think is that these carbon markets right now, they are not like very efficient, because we are not like stopping to pollute. We are just, countries are just paying to other countries. So this currency, what looks for is that countries increase their investment in green energies. So as much as countries invest in green energy, they produce green energy, they are going to get money. So it will create like a different kind of market as the totally different to everything that we can see until now.
Okay, gotcha. Yeah, no, I thought this was either incredibly crazy or incredibly genius, or both combined. It's very interesting to see this this idea. No, I got that point. Yeah, I know that they're inefficient, but this is also why I thought that maybe if it works on a different currency, you know, it might be more efficient in the, like, if we think about it, a limit, you know, you fix limit within what we can, you know, we have a carbon budget, so why not monetize it, you know? Like, there is X amount of carbon we can emit. So that was more my thinking. So if you link it to a currency, because it's traceable, I mean, all the pros of having an online currency could be applied. But I see your point. But yeah, thank you.
Thanks to you.
Thank you so much, Lea, for your question, and to Jesus for your answer. Once again, I would like to open the floor to a final round of any questions or comments before we close the session for today, but also before we head on to closing this week's workshop. Okay, seeing as there are no more questions or comments or remarks from the audience and attendees, I would now like to take this opportunity to thank each and every one of you, and to thank some of the key members for this presentation. Firstly, I would like to thank our partners at UNEP and ASSELLAU, Professor Patricia Kamirin-Borte, and our representatives at the German Environment Agency, Dr. Harold Ginsky. On behalf of the organizing committee, I would like to extend a heartfelt vote of thanks to our partners for your invaluable support and contribution to our conference. Your partnership and sponsorship have played a crucial role in making this event a grand success. Your commitment to our mission and vision has enabled us to bring together a diverse group of experts, scholars, and professionals to share their knowledge, insights, and expertise. We are truly grateful for your trust and confidence in our organization and our mission. Your contributions have made a significant impact in our community, and we hope that this partnership will continue to grow and flourish in the future. To our speakers and experts and presenters, it is my great pleasure to extend our deepest gratitude to all the esteemed speakers who presented at this year's workshop. Each of your presentations were truly inspiring, informative, and thought-provoking. Your expertise and knowledge in your respective fields is truly remarkable and have left an indelible mark on the minds of all the attendees. We are grateful to have had the privilege of listening to your insightful and informative speeches. You have provided us with valuable insights and knowledge that will help us in our respective fields. Your presentations have given us new ideas and opportunities to explore and implement in our own work. Your contribution and hard work are truly appreciated, and we are grateful for your time and effort. Thank you all, and we hope to have the pleasure of your presence again in the future. To my fellow doctoral candidates, I would like to express our sincere gratitude for your valuable contributions and presentations at the conference. Your hard work and dedication have truly made this conference a success. Your research and findings have enlightened us and have contributed significantly to the advancement of knowledge in our field. It was truly inspiring to witness your passion and enthusiasm for your research, and we are certain that your efforts will make a significant impact in the academic community. We understand that it takes a lot of effort and dedication to complete a PhD, and we commend you on reaching this important milestone in your academic journey. Your presentations were well received and were a testament to your hard work and dedication. Once again, we would like to extend our sincerest gratitude to all of you for taking the time to present your research to us and for trusting us with your research. We wish you all the best in your future endeavors and hope that you will continue to make important contributions to your respective fields. To the attendees, thank you once again for joining us each and every day. To each and every one of you, you have made this event a grand success. Your thoughtful questions, valuable insights, and constructive feedback have enriched our discussions and helped us to explore new fields and solutions. We hope that you found it informative, engaging, and enjoyable. And we look forward to welcoming you at future workshops to come. To my team at ClimLaw, words cannot express my gratitude for your unbelievable support and your assistance during the establishment and execution of this workshop. We could not have done it without the help and assistance of one another, and for that I am truly grateful. To give an overview of last year's workshop and the outcome thereof, there has been a report of last year's workshop posted on the ClimLaw Graz website. I will be sure to share the website in the chats for anybody to see and for everybody to access. We also had contact with our doctoral candidates from last year's workshop in October of last year as a follow-up for the previous year's workshop and its outcomes. During both the report and the follow-up session, we engaged with not only attendees and experts and professionals, but also our doctoral candidates and potential candidates for this year's workshop. Before I go any further, I would like to take this opportunity to show you one of the distinct outcomes of last year's workshop, and that is a specific publication aimed at last year's workshop proceedings. So the publication is titled Climate Law and Litigation, Planetary, Regional and Societal Perspectives. This is the first edition of the publication, matching the first edition of the annual PhD workshop. And as such, we hope to conclude further publications of this nature at the end of each of our PhD workshop. As you can see, the collection of works presented here also consists of some of the presenters that presented at this year's workshop, and we look forward to engaging with each of our presenters and as well as our PhD candidates to contribute to next year or this year's upcoming publication. In closing, it has been a privilege to host and coordinate this PhD workshop on climate law and litigation. As we come to the end of this event, I would like to take a moment to reflect on the valuable insights and discussions that we have had over the course of these past few days. Our workshop has brought together some of the greatest legal minds in the field of climate change and environmental law. We have discussed climate change in the times of global crisis, the perspectives of national and international climate litigation, loss and damage, sustainable trade, and last but not least, climate change and just transitions. This conference has given us a unique opportunity to engage with each other, to share our ideas, and to work together towards a common goal. We have seen the importance of cross-disciplinary collaboration and the role that legal practitioners can play in shaping climate policy. As we leave this conference, I urge you to continue to engage in the important work of fighting climate change. Let us use the knowledge and insights we have gained to make a difference in our respective fields. Let us continue to work towards a sustainable future for all. I once again thank you all for your participation and contributions to this conference. Stay safe, and I hope to see you all again soon. Thank you, and have a great evening and a great day for further. I will certainly be in contact with any and all people who were interested in follow-ups from this year's workshop, and I wish you all the best. Thank you.
Thanks to you. Bye.
Thank you, Larissa. Bye.
Thank you.
Thank you. Bye.
Thank you. See you soon. I hope so.
Thank you. Goodbye.